Civil law, not criminal law.
Extension already.
To the motion. which
Lordship,
is-
then I can file.
Expired.
Because you are still within time.
Lordship.
The
Interim order
the
expired.
interim order is extended for 5 weeks from the order means you are still within time.
Already expired.
No, 5 weeks.
14th, 14th,
Fourth week of May 2020.
no.
No, no, no.
14th,
No, no, no.
November.
November.
It was for
Correct, yes. Further extended of November. 5 weeks.
You're just on time, file it
Just on-
immediately. File
Got
it immediately.
Lordship.
No order need be passed. File the application, it will be automatically taken up for hearing, the extension. You need to file an extension
Lordship,
application.
that's.
Next.
Madam, for the petition.
Served. Run 3.
Yes. 10/4/2020. Has been served, my lord.
Where is your service?
My lord, the service, I think I've misplaced in the
Not
other,
today?
my lord, it is already filed in other matter, my lord. Mistakenly.
Other matter, this matter there is no.
Another CRR before this court. only, my lord.
Another
I have
CR
served to the learned advocates, my lord, both were appearing.
are both appearing, then I can deal with the matter.
It was appearing, my lord. Mr.
Oh,
Hilol Shapotar and
Private officer
Mr.
party.
Hilol Shapotar was appearing.
Where is he?
He's in court number 1.
My lord, if it could be passed over, I will.
I'll pass it over. If he's there, I'll consider this. Passed over.
I beg to appear for the petitioner.
Yes,
That,
service,
It's for extension of the interim order.
service,
Service is completed. Mr. Luxam is appearing probably for the state authorities. Millet. For the OP number 2, Millet, there was a direction upon us lastly to ensure service on the OP number 2. Millet, this is my affidavit of service. It is delivered.
it's way beyond time.
Beyond time, Millet. It cannot be doubted.
Not
Millet.
only beyond, it's way beyond.
Way beyond. That's right. Millet.
Have you explained the delay?
Millet, probably not so many words.
28th June and 10th July.
Millet, para 4. Millet, para 4 is an explanation, but not in so many words.
Inadvertence.
It is slipped out of our
Who is appearing for the private opposite party?
private opposite. There's no private opposite party. Millet.
Only the
It's the officer under the Shop and Establishments Act who initiated the complaint.
So he's also the
He's
state.
also the state. He's also individually. He's also
So
served.
Mr. Luxam is appearing for.
Mr. Luxam can represent both of them.
Let me revive this and extend this.
Grateful.
For a
Millet,
limited
extremely
period.
grateful.
Affidavit of service, third learned counsels for the parties. Paragraph, it appears that the interim order granted earlier expired on 28th June 2024. Stop. The present application has been filed on 10th July 2024. Paragraph, be that as it may, comma, since the petitioners were favored with an interim order upon consideration of the material on record, comma, the said order revived and extended till 31st January 2025 or until further orders, comma, whichever is earlier. And disposed of.
Grateful. Millet. Had the circuit been of 10 days, 2 weeks, I would have pressed for final hearing because Millet,
I know, that's this time I am facing difficulty.
yes.
You come all the way and you don't get sufficient time, it's difficult. Next,
Hotel Lordship, I am for the petitioner, extension of interim order, Lordship.
served,
Served, Lordship, but yesterday I filed affidavit in service, which is kept on record. Within time, Lordship.
within time,
Filed within time. হ্যাঁ,
Private
সাথে
opposite party
serve করবে, service related।
served. So I'll extend this for a limited period.
Yes, madam.
Affidavit of service. None appears for the private opposite party despite service. Paragraph, the interim order granted earlier is extended till 31st January 2025 or until further orders, comma, whichever is earlier. Run display. Next.
Item number 15.
15. Not today. Not today.
17.
My lord, 16 and 17 may be taken up together.
79?
16 and 17.
Oh, I've just called 16 and you were not there.
I am sorry, my lord. I did not hear. I'm very sorry. Very sorry.
16.
My lord, this is for the extension of the interim order, my lord.
Have you
What has
served?
been? Yes, my lord, sir. Mr. Pal would be parceling the affidavit of service.
Where is your application for extension?
My lord, can do. Sorry.
Can two.
Can do.
Who is appearing for the opposite party?
My lord, I'm not certain of that because it is upon admission.
I'll extend this for a limited period. Affidavit of
My
service.
lord, may I ask something?
Yes. Yes. You're not audible. Frozen.
Yes, my lord.
Yes.
Can it be extended till February because I would be going out for my mother's treatment. She has a very rare genetic disorder now.
Very well. Very well. I'll do it. I'll extend it. Till,
From February, we will.
I'll extend it till February.
My-
Affidavit of service. None appears for the opposite parties despite service. Paragraph. the
My lord.
granted earlier is extended till 28th February 2025 or until further orders, comma, whichever is earlier. Plan disposed of. What about the next matter?
Both this
do
16 and
2
17,
minutes.
16 and 17 is
17.
Seven.
The affidavit of service in 17. Affidavit. The same opposite parties. Same order. 16, 17, same order. Yes, you are in? Oh, 12 is the extension matter. 12 to the extension. matter.
The affidavit of service has been done.
Oh, you've got it.
But what-
Mr. Luxam is appearing here. 12 today.
Item 2.
Extension
My lord, it was expired on 30th November. My lord, application is filed before expiry.
within time.
Only by pair, but can it please state for hearing?
I cannot. The next circuit will fix.
Yes, madam.
I'll
My lord, it is running in the list.
I'll
for hearing,
extend
my
it
lord,
to
so
31st
possibly
January.
is not taken up.
mention before the next circuit. Affidavit of service, 8 to 12. Affidavit of service, heard learned counsels for the parties. Paragraph, the interim order granted earlier is extended till 31st January 2025 or until further orders, comma, whichever is earlier, plan disposed of. Now within time. Next,
Lordship, one indulgence if I may. Item number Lordship 1670.
yes,
Lordship, it was just extended right now. I just had one submission to make. I am for the opposite party. That
Order has been passed, sir. I cannot hear a submission after the order.
All right, I was just like, great friend, your lordship, I'm giving my.
Give your
best
appearance,
request.
give your appearance. Learn the affidavit of service, heard learned counsels for the parties. None appears to give.
I am for the petitioner application. The application under section 311 of the CRPC was turned down by the trial court, for which we have applied for the recall of the order. By the order passed by this learned court, we were,
Served?
the copy has been served, but we were, the matter, I am led by Mr. Amlesh Roy, who is in
But why
principal.
don't you plead the private opposite parties? The de facto complainant? He would have
My-
opposed the prayer before the learned trial court.
My lord.
Yes?
Mr. Roy will appear in this matter. He is in principal bench. So, my lord, kindly fix it in the next circuit, my lord.
Next circuit.
Next circuit. There is no interim.
Specific questions was asked.
Madam.
Time or not, specific questions.
Madam, for that we have applied for the certified copy of that particular application,
Let
which
him
was
come back.
filed in the court bill.
On prayer of the petitioner, the matter be placed before the.
On the
next
first
available
day of the circuit, my lord.
circuit. I cannot fix a date, sir. You have to mention.
My lord, liberty may be mentioned. Liberty may be
Yes,
granted. to
it
me.
will be placed before the next circuit. I have recorded that.
My lord.
Next.
I'm paying for a short passover.
Today, no pass.
My lord, Mr. Acharji is for the opposite party. He's going for a bail hearing. My lord, that is why.
Passed over.
You are doing the matter.
Oh, you are appearing?
Yeah,
That's fine.
yeah.
Very well. Let me take it up.
My lord, in this matter on 14/6/2024. The warrant has been issued against the my lord petitioner. My lord, the impugned order is at page my lord 37. My lord, what happened? My lord, on 13th March 2024, petitioner filed an application before this honorable High Court and subsequently it was allowed. And in the order, there is a direction to meet the investigation officer once in a week till the completion of the charge sheet. But on 15th March, he had been surrendered before the trial court, but my lord, the learned advocate of the trial court did not advise him to appear before the police station, neither make any thana hajira khata. That is why my lord, he did not appear. But my lord, each and every date he appeared before the learned trial court and my lord filed his hajira. My lord, subsequently on 36, 37 though. Subsequently, my lord, on 14/6/2024, the investigation officer put up the matter and my lord filed an application for cancellation of bail on the ground that he has not appeared before the Thana. And subsequently, my lord, the learned trial court cancelled his bail. My only submission is that, my lord, setting aside the order, each and every day, my lord, as your lordship directed, I will appear. By tomorrow, I will appear before the Thana, my lord.
Where is the order of this court? The bail order?
One.
Have you annexed
Page
that?
16, 17, my lord.
Page?
16 and 17. 17 is the operative.
Yes, Mr. Lutz.
Because of his conduct, my lord, he was
Let me set it aside. Let him comply with the conditions, right? The heard learned counsels for the parties. The petitioner was granted anticipatory bail by this court. The day order dated 13th March 2024 in CRM within bracket A, 186 of 2024. subject to condition that he would join in the investigation and make himself available for questioning to the investigating officer once every week till completion of the investigation. He was further directed not to intimidate any witness or tamper with any evidence in any manner whatsoever, and also not to leave the local limits of the concerned police station without leave of the investigating officer. The petitioner failed to comply with the portion of the order directing him to appear before the investigating officer once every week. And the same was brought to the notice of the learned trial court by the investigating officer. Stop. By the order impugned dated 14th June 2024 in NDPS case number 48 of 2023, comma, the learned trial court, being the learned additional sessions judge, comma, first court, comma, Kuch Bihar, cancelled the bail granted to the petitioner. The petitioner, paragraph, the petitioner is aggrieved by the said order and seeks quashing of the same. Learned counsel for the petitioner submits that the petitioner was not informed about the conditions laid down by this court by his learned counsel, for which he was unable to comply with the said condition. Stop. The petitioner undertakes to comply with the conditions laid down by this court. Strictly and without any further lapse. Paragraph. Learned counsel for the state prays for necessary order. Paragraph. It is not in dispute that the petitioner failed to appear before the investigating officer once a week in compliance with the direction of this court, for which the learned trial court cancelled the bail of the petitioner by the impugned order. Stop. Since the petitioner undertakes to comply with the order of this court in its true letter and spirit, comma, the petitioner may be, he may be granted, he may be granted a further and last opportunity to remain on bail upon strict compliance with the conditions laid down by this court earlier. Paragraph. In view of the above, the order impugned dated 14th June 2024 passed by the learned additional sessions judge, comma, first court, comma, Kuch Bihar, within bracket NDPS, in NDPS case number 48 of 2023 is set aside.
Good.
Paragraph. The petitioner shall continue to remain on bail subject to strict compliance of the conditions imposed upon him. V-Day order dated 13th March 2024, passed by this court in CRM within bracket A 186 of 2024. Paragraph, in the event of failure of the petitioner to comply with any of the conditions, comma, the learned trial court shall be at liberty to cancel his bail without further reference to this court. CRR disposed of urgent certified website. Next. Concluding. Next.
Item number 20 kindly takes up at 12, Lordship. Mr. Owen Banerjee will be there on the virtual board. Kindly.
Please do not fix times like this is difficult. Passed over. Next.
Lord, in item number 21, I beg to appear for the petition.
At the motion stage.
You are at the most.
Yes.
Lord, this matter pertains to a very short question of law that, my lord, the validity of the section 505 subsection 2 of the penal code, not how and when that is to be applied. Lord, in this matter, the petitioner is a person from Bardhaman. One fine evening, he was surfing to his Facebook account and he shared a post. Because of that, my lord, a case has been lodged against him in Darjeeling. My lord, through his email, my lord, 41A notice under section 41A was served. He appeared before the Darjeeling and, my lord, to the reasons best known to the investigating agency, he was arrested, my lord, when he went there to comply. Now, my lord, I would apprise your lordship only on 3 points.
He is
my lord.
still in custody.
No, my lord, he was granted bail thereafter, my lord. My lord, kindly, if your lordship kindly takes up, my lord, 5052, my lord, I will apprise on 2 grounds, my lord. Got it?
Yes.
My lord, kindly sees the section, my lord, the statements creating or promoting enmity, hatred, or ill will between classes. Whoever makes, publishes, or circulates any statement or report containing rumor or alarming news with intent to create, promote, or which is likely to create or promote on grounds of religion, race, place of birth, residence, language, caste, or community, or any other ground whatsoever, feelings of enmity, hatred, or ill will between different religious, racial, language, or regional groups or castes or communities shall be punished with imprisonment, which may extend to 3 years, or with fine, or with both. Now, my lord, I'll place my case, my lord, on the phrases, that is, whoever makes, publishes, or circulates. Now, my lord, my submission is that these 3 words are not to be taken separately and in a manner where in mutually exclusively, my lord, they may not be taken.
There is an or it's disjunctive.
My lord, I will apply. They are complementary to each other, and to attract this section, my lord, is my submission that these 3 has to go one complementary to each other. My lord, I'll apprise your lordship with this. My lord, kindly takes up.
Investigation is going on.
My lord, investigation is going on. My lord, otherwise I would have started with section 196 with the compliance. My lord, that
And you are on bail.
I'm on bail.
So why
my
did
lord.
you serve and come back?
My lord, I will require the stay, my lord, and for a
Stay of why? Why do you
my
require
lord,
a
I
stay?
will require this, my lord, because I tell your lordship, he is a very indigent person from Bardhaman who has just shared this post. For that reason, my lord, once he was arrested, when he was served with the notice,
That part is
thereafter,
over.
that part is over. Thereafter, my lord, and date after date, he is filing Hajira. And for that reason only, he has to come to
Filing
Darjeeling
Hajira where?
before the CJM Darjeeling, my lord. Before the London
When
CJM.
charge sheet is not submitted, why do you?
My lord,
file
that is the problem, my lord. There are 3-4 dates till now where, and my lord kindly sees the complainant is an advocate practicing in Darjeeling court. My lord, I have not filed any case before against him or
You're
anything,
referring to
but
which paragraph? Please show me.
my lord, kindly sees paragraph number 11, my lord. Internal page number 436, paragraph 11. And my lord, this also substantiates the another ground I'm going to take in this matter, that is the intention, the mens rea, which is absolutely required for attracting this section, my lord. Kindly take my lord, paragraph 11.
This is mens rea, yes.
This mens rea, and 12, my lord. The main distinction between paragraph number 12, my lord. The main distinction between two offenses is that while publication of words or representation is not necessary under the former, that is 153A, such publication is sine qua non under section 505. The words whoever makes, publishes, or circulates used in the setting of section 5052 cannot be interpreted disjunctively but only as supplementary to each other. If it is construed disjunctively, anyone makes a statement falling within the meaning of section 505 would, without publication or circulation, be liable to conviction. My lord, that's the reason, my lord, it has been incorporated, my lord.
This is not a verbal statement that the petitioner has made. A statement in the Facebook is meant for publication and
My
circulation.
lord, what he did
Please
is
show me the
just-
statement.
My lord, that is not there. That is another thing in this matter, my lord. If your lordship would kindly see the petition. That is not there. Only the link is, my lord, the facebook.com/ the link, my lord. If your lordship would kindly comes to page number 12. He did not publish it, my lord. He only shared it.
That is circulation.
Yes, my lord. And circulation mutually exclusively cannot be applied, my lord. He has to make it, publish it, and circulate it, my lord. That's my ground, my lord.
Making and circulation is there.
No, my lord, he did not make it. My lord. Kindly sees, kindly takes up
Statement was
the.
made by him.
No, my lord, kindly takes up. It was made by another person who is on anticipatory bail granted by this High Court. It was not made by him. It was made by one person. Kindly takes up the FIR, my lord. With due respect, I, such and such, son of such and such, by profession legal practitioner, resident of Siddiqui building, HD such and such address, would like to draw your kind attention that there has been a circulation of by the aforesaid mentioned page in Facebook where the vlogger, whose name is not known, has clearly stated in his 2.38-minute video that he is making instant video to show red light area of Darjeeling from Lamahata to Darjeeling and having the caption as Darjeeling red light area, Nehru Road. In the video, the said vlogger starting the video 1.2 minute, he stated that he is going to show the red light area of Darjeeling, but the most surprising part share in the video showing the red light area and the woman shown standing in the area is not of Darjeeling but of some unknown location, and such video circulation was where such and such of different location are project in the name of Darjeeling such and such area is a threat to the society security of female and society being a school going girl or any woman, my lord. It has been written, my lord. In this manner, my lord, the only in the rest he has substantiated, my lord. It's
Yes.
difficult to, my lord. My copy is slightly illegible. Now, my lord, he did not make it, my lord. Kindly comes to the forwarding when he was arrested, when he went to comply with the.
Difficult to judge at this moment because I do not even find the.
Because they are the proper operator, whether he has used his finger to circulate or not.
Cyber
No,
cell
they
Darjeeling.
cannot do that, my lord. The post is not there. The link they have.
I know the post, the language, I do not find it here. It's only interpretation of the video.
I heard regarding this case, Manoj, because there was a video Manoj posted in the Facebook. Somebody.
This is not the person who has posted it.
Manoj, it was not the one, but so we need the case diary regarding his role.
Yes, the case diary may be called for, my lord, but I need to have a stay, my lord, in this matter, my lord, because I know even even if a short stay is given, my lord, it will be very difficult for him to come and affirm a petition for extension, my lord. I know this is for a fact.
I think charge sheet is pending, my lord, in this case, I will.
Actually, since charge sheet has not been filed, I think let the investigation proceed. You
My
are
lord, against
protected.
me, my lord.
You are protected.
My lord,
Let
my
us
bail
see,
is there.
There may be an FRT also against you.
Yes, they
So
might
this is
me.
premature to stop the investigation as a whole. And I
My
cannot
lord, I
split
will,
up investigation.
I will apprise your lordship with your lordship's order and various other.
Even to find you innocent, the investigation has to
My
proceed.
lord, kindly on this, kindly sees if on the face of it, if an offense is there. My lord, kindly sees.
I cannot see that because the the post clip is not there.
Yes, that is the problem, my lord. The post is
So
nowhere.
the CD has
The-
to be there before the
My
court.
lord, let the state come.
Serve and come back, let the
My
investigation.
lord, I
continue.
will serve and come back. My lord, the stay is absolutely.
Not at all, not at all.
My lord, then kindly record one thing, my lord, that there should not be any further date before the charge sheet. My lord, let the charge sheet be filed. I'll come back with.
Let him appear virtually before the investigating authority.
Yes,
Let him, since you're a resident of Gurdwan, appear virtually.
my lord, kindly.
That will help you to
My
some
lord,
extent.
my lord.
Let the case diary come.
Another question, so if the stay is granted, my lord.
No. I
The
can
stay can be partially granted. There.
No, that will not.
But your
really- that
lordship
will
pleases, I
create,
will
that
have
will
no,
create more confusion, more
no difficulty. my lord.
complications.
No difficulty.
Yes.
my lord.
Let him appear virtually. The petitioner seeks quashing of Cybercrime Police Station, Darjeeling, case number 3 of 2023, dated 9th August 2023, under section 505 within bracket 2 of the Indian Penal Code, corresponding to GR case number 150 of 2023, pending before the learned Chief Judicial Magistrate, Darjeeling, primarily on the ground that he was not the author of the alleged post which appeared on Facebook. Stop. The author of the post has been granted anticipatory bail. Stop. The petitioner is also on bail. Paragraph, the matter needs to be heard. The matter needs to be considered upon perusal of the case diary. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench. Paragraph, since the petitioner is a resident of Purbo Bardhaman, he may respond to the calls of the investigating officer in connection with the present matter through the virtual mode.
So great.
Next.
For the petition, my lord.
Yes. Since when is it pending? You are the de facto complainant. You are the de facto complainant. You are the accused. For no reason. How many witnesses are there? Total 5 witnesses. Where is the charge sheet? Yes, I've got it. 5 witnesses within 6 months from the next date. Since the innocuous prayer of the petitioners is for expeditious disposal of GR case number 1962 of 2012, pending before the learned Chief Judicial Magistrate, Jalpaiguri, the matter may be considered without service of notice upon the opposite party. Stop. The opposite party shall not be prejudiced by an order directing expeditious disposal of the case. Paragraph, it appears that charge sheet was submitted On 26th October 2012, and charges were framed on on 3rd March 2015. Stop. Charge sheeted witness number 1 has been partially examined on 23rd August 2016, right? And since then, there has been no further progress in trial. Paragraph in view of the above, comma, the learned trial court is directed to take the proceeding to its logical conclusion within 6 months from the next date of hearing fixed before him, comma, without granting any unnecessary adjournment to either of the parties, comma, in accordance with law. CRR disposed of, as Next. Preferred. That has been disposed of. So you need to file a joint application. This matter also should be amicably settled, right? You say that the matter is amicably settled. Annexure E, yes. It was withdrawn with liberty to sue afresh. That is not called amicable settlement. Where is the complaint? Where is the complaint? I'll stay this, serve and come back. Is he the only accused or there are other accused also? So he's the only accused, so I'll stay this with this petitioner only, right? The petitioner seeks quashing of GR case number 1438 of 2018. Charge sheet submitted. Charge sheet submitted. 1438 of 2018 pending before the learned Additional Chief Judicial Magistrate, Siliguri, on the ground that there was a business transaction between the parties and the petitioner stood as a guarantor for recovery of the allegedly due amount from one Indu Agarwal, proprietor of Messrs. Nitesh Trading Company, who purchased tea leaves, cha, worth rupees 10,73,057.38 from the complainant's company. Paragraph. The dispute prima facie appears to be a money claim raised by the private opposite party against Indu Agarwal, wherein the petitioner was a guarantor. Paragraph, the matter needs to be heard on merits. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph. Further proceedings of GR case number 1438 of 2018 pending before the learned additional Chief Judicial Magistrate, Siliguri, be stayed with the petitioner till 31st January 2025 or until further orders, whichever is earlier. Mention. Next. Yes. Yes.
The petitioner lodged a complaint against the opposite party number 2 regarding illegal construction of building. That complaint was lodged on 9th December 2022. Thereafter, again, another complaint was served upon the concerned authority on 20th December 2022 regarding his illegal construction without having a building plan. Now, in retaliation, the opposite party number 2 lost a FIR against me. The FIR is at page number 37. The FIR was drawn under section 354 and 354D. The relevant page is page 38. If I read for your lordship, the third paragraph is important. On 2012, the day when I lost another complaint, that day itself. On 2012-2022, at around 5 p.m., said Bishambar Prasad has come to my shop and asked for some grocery items. At that time, during exchange of grocery items with him, he suddenly caught my hand and gave me wrong proposal.
Charge sheet submitted.
Charge sheet has been filed. Now kindly comes to the charge sheet. Charge sheet submitted, 354D gone, only 354. Now can you see what is stated in the charge sheet? Page number 40. Page paragraph number 17. The gist of the on 2012-22 at about 17 hours, one Bishambar Prasad came at complaints grocery shop, and during exchange of grocery items, he gave her ill proposal. On protest by the
Where are the 207 papers?
Lordship, I had applied for, I did not take this.
I'll
Now-
stay this for the timing, serve and come back.
Great.
You are the only petitioner.
I'm the only
accused.
I'm the only accused. Great.
The petitioner seeks squashing of GR case number 5495 of 2024, pending before the learned additional Chief Judicial Magistrate, Siliguri, Darjeeling. Stop. Paragraph. Learned counsel for the petitioner submits that the petitioner lodged complaints against the private opposite party alleging unauthorized construction without obtaining sanctioned building plan. Stop. As a retaliation, the present complaint was lodged. Stop. Charge sheet has been submitted under section 354 of the Indian Penal Code. Paragraph. The matter needs to be heard on merits. Paragraph. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph. Further proceeding of GR case number 5495 of 2024, pending before the learned additional Chief Judicial Magistrate, Siliguri, Darjeeling, be stayed till 31st January 2025 or until further orders, whichever is earlier.
25.
Next.
For one information, that complaint which I made It was taken up by the authority directed for demolition of the building because the entire building is without building.
So she's angry on you.
She's angry on basically.
Next.
No, item number 25, my lord, I was told, my lord, senior advocate Vikas Ranjan Bhattacharya will appear, my lord. He prayed, requested me to take time, my lord, can be fixed on Monday, my lord.
Next circuit, Monday will not be possible. On prayer of the petition, the matter,
Item number 25, my lord. I am for the
Yes.
petitioner, my lord.
yes,
My lord, I am for the petitioner, my lord.
you're for the petitioner, you said.
My lord, she is appearing virtually, she is instructing. me, my lord.
Oh, you're asking for time, isn't it?
Yes, my lord.
Next
This
circuit.
by my
Next
lord.
circuit. On prayer of the
No, my
petitioner,
my
the
lord.
matter be placed before the next.
Kindly
available
fix it, my lord. Monday, my lord.
Monday will not be possible. Next.
My lord, this matter is leading by my lord, senior
Further
advocate, Mr.
adjournments on Monday will not
Vikas
be
Bhattacharya, my lord.
Yes, yes, next circuit. Next.
Not available, my lord. Kindly.
But I am for the petition. My lord, sealing, my lord, an order, a conviction order passed by the assistant session judge Alipurduar, but I preferred an appeal before the district and session judge. My lord,
Appeal was
was
dismissed for non-prosecution.
non-prosecution. my lord. My lord, my lord, that is the order dated, my lord, 24th of September 2024.
Is the law which enables an appeal to be disposed of for non-prosecution, a criminal case?
My lord,
Has to
strange,
be disposed of on merits.
strange, my lord.
I'll set this aside
Lordship,
without further ado.
lordship, lordship,
No reason for wasting more time on this.
lordship. Strange.
Which court? District judge,
Dismissed.
district judge.
District judge, district and session judge.
Unfortunate. The petitioner. Yes, how is that possible? Unknown to law.
Strange, my lord.
And that to an order not by junior court. This is
Yes,
by the.
Yes,
district
assistant
judge.
session judge.
No, the order is by the district judge.
No, my lord, I prefer the appeal against the order dated assistant session judge passed by the
Oh. No, that is fine. Let him deal with it on merit.
lordship. Strange, my lord.
The petitioner seeks washing off. The petitioner has assailed the order passed by the learned sessions judge, Alipurduar on 24th September 2024 in criminal appeal number 32 of 2024, whereby the learned judge has dismissed the appeal for non-prosecution due to failure of the petitioner to take steps to appear before the learned court. Paragraph. The appeal was preferred by the petitioner against where is the conviction order?
Conviction order is, my lord.
Have you annexed it?
Yes, my lord. My lord,
Not
that
annexed.
unfortunately has not been
Not
annexed.
annexed. No, keep it in.
Child.
Paragraph 4, it appears from the order impugned that on the date fixed for admission hearing, the petitioner was found absent without steps for which the appeal was dismissed for non-prosecution. Stop. Dismissal of a criminal appeal for non-prosecution is unknown to law. Paragraph in view of the above, the learned sessions judge, Alipurduar is in view of the above, the order impugned dated 24th September 2024 passed in criminal appeal 32 of 2024 by the learned sessions judge, Alipurduar is quashed / set aside. Paragraph, the learned sessions judge is directed to deal with the appeal on merits and pass a reasoned order upon affording reasonable opportunity of hearing to the parties, in accordance with law.
Lords.
CRR disposed of as a certified website. Next.
My lord, I am appealing for the petitioner, my lord. My lord, I have come before your lordship, my lord, for quashing of this criminal proceeding against the petitioner which has been initiated under section 306 of the Indian Penal Code. My lord, as per the FIR, the allegation is that the wife of the victim husband who has committed suicide by consuming insecticide is the main, my lord, is the main person for this commission of
Charge
suicide.
sheet submitted.
Charge is submitted. And the petitioners before your lordship, who are the mother of that wife and younger sister of that wife, they are involved in this alleged offense. Lordship, kindly see the contention of the FIR, my lord, page 12 of my petition.
Wife's mother and sister.
Wife's
Petitioners.
mother, yes, and younger sister.
And who is the private opposite party?
The de facto complainant is the
Father?
father of the victim husband. My lord, page 12, lordship kindly comes. My lord, I'm just reading whether, lordship kindly see whether there is an ingredient of 106 or not. স্যার বিনীত নিবেদন এই যে আমি শ্রী দুলাল শীল শর্মা পিতা বীরেন্দ্র শীল শর্মা গ্রাম সাচেন্সার কোচবিহার অত্র এলাকার স্থায়ী বাসিন্দা আমার তৃতীয় পুত্র স্বর্গীয় পুলক শীল শর্মা গত 30/9/22 তারিখে শুক্রবার সকাল 11:30 নিজের বাড়িতে কীটনাশক ঔষধ পান করে এবং তারপর চিকিৎসার জন্য কোচবিহার MJN হসপিটালে নিয়ে যাওয়া হয় এবং সেখানে তার মৃত্যু ঘটে। উল্লেখ থাকে যে আমার বৌমা শ্রীমতী সোনালী শীল পিতা শ্রী হরিমোহন শীল গ্রাম পোস্ট অফিস রাধানগর থানা কুমারগ্রাম জেলা কোচবিহার আমার পুত্রের ওপর নানা রকম মানসিক অত্যাচার শুরু করে এবং তার ফলে আমার পুত্রের মৃত্যু ঘটে। আরো উল্লেখ থাকে আমার পুত্র স্বর্গীয় পুলক শীল শর্মা হাসপাতালে চিকিৎসারত থাকাকালীন এবং শেষকৃত্য সম্পূর্ণ হওয়ার সময় বৌমাকে উপস্থিত থাকার অনুরোধ করা সত্ত্বেও সে অনুপস্থিত থাকে। Now, my lord, this allegation, these 4 lines against the petitioners before your lordship. আরো উল্লেখ থাকে যে এই মৃত্যুর পিছনে আমার বৌমার মা শ্রীমতী শেফালী শীল, বৌমার বোন শ্রীমতী ঝুম্পা শীল, স্বামী গোবিন্দ শীল, গ্রাম সাচেন্সার আর এর সঙ্গে জড়িত। So, my lord, there is no ingredient of abetment or inducement, my lord, which is the primary ingredient of, my lord, section 306. Now, my lord, thereafter, my lord, lordship kindly comes to page 13. It is the allegation, it is the complaint of the that wife. The reason, my lord,
You are on bail?
I'm on bail. I'm on bail. My lord, my humble submission.
Please serve and come in.
My lord, my humble submissions before your lordship is this, my lord, there is no ingredient, my lord, which attracts section 306 against the petitioners before your lordship. Now, lordship, the charge sheet has been filed, my lord, that is written in a so-so manner. My lord, there is nothing to that effect that found by the investigating officer.
Where are the 207 papers?
My lord, 207 papers, lordship, I craved leave, my lord, because at the time of filing, I could not get it. My
Now
lord,
you have received the
yes, my
copies?
lord, I'll file it on by the way of supplementary here also, lordship. Nothing with respect to the,
Please come back with the 207 papers.
my lord,
I'll consider this up.
my lord, my lord. My
You
lord,
have the
my-
papers with the.
my lord,
paper.
I just today only I have received the papers in my hand. My lord, lordship, one humble submissions, my lord, kindly direct to bring the CD.
When is the next date?
My lord, next date in the month of January end, lordship.
January end, so you
Yes.
have some time with you.
Yes,
I'll
sir.
give direct service. Submission of, I'll grant you liberty to file a supplementary affidavit, come back with the 207 papers. Because since you are on bail, nothing will happen before the end of January,
Lord,
right? The next, because investigation is over.
investigation.
Serve,
is
I'll
over.
direct
But my lord,
production of
the-
CD also.
Yes, your lordship, but my lord, can it be, my lord, a stay may
Why-
kindly
why
be
do you
granted up
require
to
a stay?
31st
Why do
January?
you require a stay?
My lord, if,
Because the next circuit is from
if,
second
yes, next circuit
and
is
the
from
date is
7th.
much
My lord,
after
if
that.
the CD doesn't come, if anything happens,
You
so
can
my
pray for
lord,
stay before the next circuit.
yes, your lordship.
In that case, you can pray for a stay before the next circuit. Why will the CD
My
not
lord,
come? The
my lord,
councils are there.
Initially stay is more easier than, my lord, after, my lord, praying for the stay, my lord. My lord,
I don't think, I don't find any reason for stay. If there was a short date, I would have granted a stay. A December date, I would have granted. That's not required. Not necessarily stay the.
Lordship. My lord, I'll file the 161 paper in the, by the way of supplement.
On prayer of the petitioners, comma, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, the petitioners have assailed the petitioners seek quashing of GR case number 1138 of 2022 pending before the learned additional chief judicial magistrate, comma, Tufanganj, comma, Kuch Bihar on the ground that there is no prima facie ingredient of offense, ingredient offense against them under section 306 of the Indian Penal Code. Stop. The petitioners are the mother and sister of the victim's wife and are on bail. Paragraph, the matter needs to be heard on merits. Paragraph, the petitioners are directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench. Case diary be produced on the adjourned date. Next.
Well, at item 28, I am appearing for the petitioner.
Mr. Ratnesh Kumar.
I am for the opposite party number.
When I am appearing for the petitioner, this is a matter of 2023, my lord. We have filed a CRAN 2 for extension of interim order. My learned junior friend will kindly, the service is complete,
Service is complete?
my lord. Madam, we kindly extend the interim order. It's a matter of 2023.
When CRAN 2, is it within time?
Within time, my lord. Filed within time.
This is 25th of June.
Yes,
Where is the
madam.
affidavit of service?
When it is with the learned junior Miss Roy, supposed to.
Well,
Suppose
she doesn't seem to have it.
Yes, madam.
Where is it?
But that I need to take instruction from.
I tender,
She is
when
not
I-
ready with the affidavit of service.
when I tender my apologies, my sincere apologies, my lord. Madam,
Yes, not today?
well then,
Pass it over.
Pass over, not possible. Shall I make it not today?
not today, my lord.
Please
If
submit
you,
the affidavit of service on the next day, because is there anyone appearing for the private opposite party?
I am for the.
He is appearing. I'll extend it.
he is appearing.
I'll extend it. Should be ready, madam, with the affidavit of service.
Extremely apologize.
Along with CRAN. Heard learned affidavit given now. Heard learned counsels for the parties. Paragraph, the interim order granted earlier is extended till 31st January 2025 or until further orders, comma, whichever is earlier.
Fixing for final hearing, Worship. Fixing for final hearing.
Mention before the next circuit. CRAN disposed of. What about the next circuit?
I am deeply obliged.
Next.
Well, 29, I'm for the petitioners. But this matter was heard, my lord has heard this matter on the last occasion. There was only, everyone had appeared in this matter.
What is the matter about?
Lordship, I am for the private respondent, Lordship.
My lord, the matter.
Yes.
Lordship, I am paid for next circuit, Lordship.
No, my lord, we did not.
Lordship,
Because on the last occasion, only one day, a day accommodation was sought for, my lord. My lord,
Last occasion means in April.
April, my lord
And
had
you
heard
don't
it.
expect me to remember this.
No, of course, definitely, man. It's very simple matter, my lord.
Lordship, this is
It's an order passed under
It's
130.
not ready today. Next circuit is from second, so come.
But can it be there on Monday?
Monday not possible. Monday will not be possible. Because we are winding up on Tuesday.
But
This time it's a shorter period, so Monday will not be possible.
this was called on Monday also. In this entire week, man, this was called. They never appeared. On the last, it's
On prayer of the private opposite party, Kamala, on prayer of the private opposite party, comma, the matter will be placed before the next available circuit bench.
Great.
Next.
Item number 30. Guardianship for possible. My elder brother just instructed me, he's in court number 3 on his list.
Very well, passed through.
Will your lordship be kind enough to indicate when the possible matters will be taken up?
After I complete the list,
The whole list, my lord.
yes, of course.
My lord, this matter, my lord, learned additional public prosecutor is there, my lord. But
Yes.
he has already left, my lord, Jalpaiguri for some urgency, my lord. So can it be?
My lord,
Next
if he
circuit.
passed over, my lord, let him come and let him.
He has already left station, my
No,
lord.
my lord,
He doesn't want to take responsibility, so
Arey
come
দাঁড়ান,
back.
আসুক না তো।
He doesn't want to take responsibility. Let the
Lord,
learned counsel come.
Lord,
I'm so grateful.
Please remind me when he comes back.
my lord, Mr. Niloy Chakraborty is there, can you short pass over, my lord? Can it be a short pass over, my lord?
Passed over.
Your lordship, I'm waiting for the petitioner. Service is not yet complete.
Service not complete.
Service not-
Since service upon the opposite parties is not complete, comma, the matter will be placed before the next available circuit bench. Next.
Lordship, learned counsel for the state is engaged in court number 1.
Passed over.
Pass over or not today? Anything at Lordship?
Let me pass it over.
PF matter, Lordship, that.
At Lordship thing.
Oh, let me pass it over.
Grateful Lordship.
Next.
Ganguly will be appearing in this matter, my lord.
34. আছেন online কেউ আছে?
Is in online.
No one.
Okay, my lord, not today.
34. 34 not today. 33 you're ready?
Lordship, he is for the PF authorities.
Lordship, 33, Mr. Ganguly actually say, given the copy.
Yes.
But so far instruction is concerned, I have not get the instruction. Lordship, kindly.
Next circuit.
Monday, Lordship. Because he is only on the part whether the payment has been confirmed or not. I have other because the company has not made party. Violation of
Very
14.
well. Not today.
Not Monday. Grateful, Lordship.
This is 33. 33 to not today. Go. Very well. 34 not today. 35. $35, no one. None appears for the petitioner, no accommodation is sought. 35. You are appearing in 35? No. The matter be placed before the next available circuit bench.
I'm for the state, your lordship. I'm holding the state.
Madam, I am late by Mr. Vikramaditya was. Case was registered under section 306 of the IPC, Lordship.
Yes.
Kindly see the paragraph number 6 of my revisional application. There is a quarrel between the children of the apartment of one.
Continue. You are competent enough. Continue.
There is a quarrel between the children of the that apartment where the such lady was decided, Lordship. Subsequently, the incident, Lordship, there are this lady was beaten by this petitioner was beaten by the
deceased
lady, Lordship. Subsequently, the after 1 or 2 days of the incident, in the group of that society, Lordship, few members of society group, they something written about the such incident that this should not be written in the society. What happened, Lordship? But subsequently, in after 2-3 days, she committed suicide, and there is no suicidal notes, Lordship.
Who is appearing for the private opposite party?
Lordship, we served, but
Where is the service?
yes, Lordship. No, but address is not found. It has been returned to.
Because her presence is required.
Very much required, your lordship.
Lordship, can we see?
No, Aditi.
Resident of Jalpaiguri,
That
no such person, you have to first serve and come back, then only I'll hear on merits. No such person in the address, you have sent it to a wrong address.
no, Lordship, we have collected the address from the charge sheet, Lordship. In the complainant has written their address.
So I would
All are
request
getting
the,
bail, all are getting bail, your lordships, and the CD is replayed, charge sheet has been filed.
no, not only that, you have to serve the private opposite party and come back. I cannot hear this matter in absence of the private opposite party.
Lordship, but they reside in the same apartment, Lordship.
Please
After
serve
this
through the local police station. Yes,
Lordship, and direct.
I will direct, yes. Affidavit of service. Paragraph, since the petitioner is unable to effect service upon the private opposite party in the ordinary manner, comma, service be effected through the, this is Bhaktinagar PS, inspector in charge or officer in charge? IC, through the inspector in charge, comma, Bhaktinagar police station, comma, Jalpaiguri. Paragraph, learned counsel for the state is requested to submit a report on the adjourned date upon effecting service. Paragraph, the matter be placed before the next available circuit bench. Why are you nervous? You are a good lawyer. You are mentioning it's perfectly well.
But with the phrase and paragraph of the, I am aware of the matter.
Do
but-
your homework and make your submissions.
Lordship, and what,
You are competent enough.
Lordship, one more submission,
Mr.
Lordship.
Ghosh,
my-
am I wrong? Am I wrong? They should be given opportunities, isn't it?
Lordship, kindly one indulgence, Lordship, we actually last date the stay was granted in favor of us, Lordship, kindly stay will be extended till the disposal
Till
of
the adjourned date.
No, Lordship,
Because
earlier
here it
order
was
till
till
the,
the,
earlier order.
it was till the adjourned date. See
Yes,
the
Lordship.
earlier order.
Yes.
The interim order granted, Rajiv, act line, the interim order granted earlier is extended till the adjourned date. Next.
For the state, your lordship. 37 and 38,
Yes.
both are connected matters which pertains to PF, Provident Fund. We are straightly on the point that company has not been made up.
You have made the payment?
Yeah, we have made that. I've annexed
Instructions?
all the relevant documents, right? with respect
No,
to that.
no, so for 37, item 37 is concerned,
Yes.
they have had some, challan that has not been confirmed from by my.
So please verify and come back.
Monday, no.
And so far, 30, there is no challan.
No, I've made. I did hold that.
So 30. That is, no, sorry, 38.
এই নিন, হ্যাঁ?
No challan.
না না দিয়েছি চালান দিইনি ইয়েটা দিয়েছি না এই যে এস্টাবলিশমেন্ট কোড একটা আমরা যে পেমেন্ট করে
Some
দিয়েছি
document to show
receiving.
that payment is
yes
made.
yes yes we have you have annexed
So I'll just make both the matters not today. Please verify and come back on Monday.
Monday
Yes?
দিয়ে দিয়েছি
Monday or Tuesday?
Tuesday, no. Tuesday, no.
Tuesday will not be possible Monday
Or next circuit, second
Monday
January.
Monday
That's why.
These are matters which I've already dealt with.
yes lordship
Several matters I've dealt with. The same order has to be there. So
Yes. I want us to verify the.
not today. Yes. Do today, huh? 37, 38, not today.
লাগবে না লাগবে
देखी फाइल देखी 8 not today को होना ना next circuit. 39, no one. None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit court. Next. Same order. Rajiv, দুটোতেই the state is represented.
state is present lordship
দুটোতেই state is represented. 41 also you're for the state,
state
same order. Next circuit.
next one.
Lord, in 42, I beg to appear for the petitioner. Lord. There is that matter where
Lordship, before start, Lordship, I have submission. Mr. Shoiko Chatterjee, appointed lawyer on behalf of the state, suddenly became ill. Can it be fixed on Monday, Lordship?
he became.
How many matters can be fixed on Monday?
No, he never. He's come with proper instruction, he's not. No. Then it will be passed over. Lord, your lordship has heard this matter substantially, my lord. And it was that matter where 180 it was charge sheeted, my lord, without the compliance of 195, and my lord, the connected section, my lord, I have Mr. Chatterjee on the last occasion has taken time to come back with another thought, my lord.
And what about the private, or they didn't appear despite
My lord,
service?
did not.
Oh, that's recorded, yes. So passed over.
Yes, my lord.
Next,
Neela.
43. None appears for the petitioner, no accommodation is sought. The matter be placed before the next available supplicant. Opposite parties,
Lordship, opposite party is the
union,
union.
where is he? Mr. Mojumdar was there. Yes, he was present.
He was present.
Not there. Shall I pass it over? Will you see if you can find
Lord.
it?
Can it be on 2 o'clock, Lordship?
2 o'clock, there are 4 matters fixed. Cannot be at 2 o'clock. Pass it over. 2 PM গুলো রাখবেন না। 49.
49 for the state, my lord.
49 petitioners?
49 Lordship praying for not today.
Not today, yesterday also paid for the day, then not.
Yesterday
next
also
Sunday.
it was not today.
Yesterday also they have paid, not today.
Next.
On prayer of the petitioner, the matter be placed before the next available circuit bench.
Each and everything holding the CD and you said.
Next.
My lords.
50.
50. My lords, I am for the petitioner. My lords, this is another PF matter. It has come on, we had taken time for taking the instruction regarding.
Verified?
Well,
No.
my lords, this is coming over the
Because of the,
report time.
they have been, the company has not been added.
Huh.
But company has been added.
My lords, it's.
State is record party.
My lords,
State is,
my lords had paid us a charge sheet as well, where at page number. At page
Yes.
number 31, my lords, where only the names of the directors have been given. As
No.
accused person and in column 1 and 2.
State is
Page-
because of state stated there earlier, on earlier occasion that the company has been added.
No, my lords, I'll
You
just.
serve the state.
Yes, my lord, last time they were appearing as well. The matter was almost heard.
Oh,
My lords-
Mr. Aditi Shankar Chakraborty is appearing for the state.
Lead by.
You're ready?
Mr. Arjun Chaudhary was, and Saurav Ganguly sir was,
You're
My
ready,
lord.
this matter?
Yes, my lord.
my lords, at page number 31, name of the accused at column 11. 2 of the directors have been named here.
Yes, and not the company.
And my lords, the name of the direct company has not even
And
been
you paid
mentioned.
the entire amount, right?
Yes, my lords. My lord, the payment challan is also annexed here. At page 35 onwards.
But Marianbari Tea Estate has been made an accused in this case.
My lord, Marianbari Tea Estate is
Where
not the
is it?
company itself.
Where is it? Accused number 1 is Anubhav Agarwal. And accused number 2 is
Anu Agarwal.
My lord, number, in the FIR, my lord,
in the charge sheet.
in that sheet.
Page 31.
The FIR has merged into the charge sheet, is it?
Yes.
Merged with the charge sheet. The 2 petitioners are the persons, not the company.
But my lord, in the FIR, my lord, the
Irrelevant. The case will stand on the charge sheet, not the FIR.
My lord, that's right.
It has in fact merged after submission of FIR.
Lord.
Nothing remains. There's no point dragging the matter. And
Since I'm minded to pass a favorable order, let them take their time. Yes,
There is no fear of 173 or something.
nothing. No prayer for supplementary also. So necessary order.
Lord, necessary order.
And the amount has been deposited, right?
Yes, yes. That is
So I'll pass the same order as I have passed in the, yes, Rajiv, same
item
order.
number 1.
Item number 1 এ যে অর্ডারটা হয়েছে জাজমেন্টটা যেটা সেম হবে আমি ওটা বলে দেবো
very grateful, my
consider that
lords.
I'll pass the same order.
Very grateful, my lords.
I don't want to work, spend my brains more on this.
Grateful, my lords. And
51.
my lords, 51, I am for the petitioner, my lords.
রাজীব এটা রিজার্ভ করতে হবে না একই অর্ডার করে দেবো রিজার্ভ করতে হবে না জানো আমি জাস্ট অর্ডার করে দেবো আজকে অমলান নেই পিএফ নেই এইগুলো চেঞ্জ হবে Yes. Private opposite party, no one.
My lords, we have served them, the affidavit of service.
No, that's recorded also.
On the last day also, they did not appear. My lords,
What is the matter now?
My lords, an FIR was registered against, my lords, an incident happened on 22nd to 2023, where at a resort in Siliguri, one person, the deceased, committed suicide in a hotel room. Thereafter, his wife, on 3rd March 2023, she lodges an FIR. My lords, may peruse the FIR at page number 37. My lords, and it's
The
type
second
co-
opposite party is the wife
yes,
of
my
the
lords.
deceased.
Yes, my lords.
Page number 36.
My lords, may find a typed copy at page 38.
Oh, you have annexed the
Yes.
207, 208 papers?
Yes, my lords, I have.
Yes, page 37.
I, the undersigned resident of Gangtok, request you to kindly investigate the death and circumstances surrounding the death of my husband, who passed away on 22nd February 2023 at Blue Mountain Resort, Siliguri, where they run an illegal poker named Country Poker Place. The place is run by one Dasho, along with Rahul Gupta and some other partner. On 22nd February 2023, I came to know that my husband is at that place playing poker on the invitation from Dasho. The details can be recovered from his call message records. Following which I called up Dasho, but he did not answer the call. After which I spoke to Rahul Gupta and told him that my husband is not well. He informed me that Tenzing is there. Tenzing is the deceased, my lord. Is there at that place and played poker on the credit given by Dasho and lost 35 lakhs rupees. I clearly told him that we are not in a position to pay the money and the institution run by them is illegal. And if any untoward incident occurred, then he, Rahul and Dasho will be responsible as Tenzing suffers from depression. My lord may note that he's also suffering from, that has been stated by his wife in the. My husband was due to return on that very day and he had informed his mother at 11:30 a.m. in the morning. I spoke to Rahul around 6 to 7 p.m. in the evening. But the same night at 2 a.m. when I called my husband, a police person answered his phone and informed me that he was found dead in his hotel room. I request you to kindly look into the matter as I strongly believe, my lord, I mark this word also, as I strongly believe that after the phone call to Rahul Gupta, they must have pressurized him regarding the money which had abated to Tenzing committing such act. Also, Rahul Gupta had my phone number via which he could have informed me, but neither did he inform me nor is taking my calls. Once again, I urgently request you to matter as to let my husband to commit such an act, the hotel in which such a thing operates, as well as the people running such an establishment are responsible and abated with my husband committing such an act.
Charge sheet submitted.
Yes, my lord, charge sheet has been submitted, 207 papers have been punished. My lord, we come to the charge sheet at page.
Assault of Expeditious.
Yes. It
Anti-motor
has not been disputed by the
Incomplete ligature mark.
306 IPC. They have filed a charge sheet under 306 IPC.
Since we are on a contested hearing, I think you need to serve a further notice to the de facto complainant. It's a serious matter and we are not at the initial stage. We are at the final hearing of the
Yes.
matter. So please serve a notice. If she still doesn't turn up, it will be considered. Her version is required, is important. The petitioner and the state are represented. Since the de facto complainant / private opposite party is not represented, the petitioner is directed to serve only a notice, serve notice upon the private opposite party.
But with permission, my lord, I have some matter in court number 1.
Intimating her that the matter shall be taken up for consideration before the next available circuit bench. If she still doesn't appear, nothing more to do.
Grateful, my lords.
Next.
After the statement.
No, to bole dibo. Aage bole daw.
Provident come, na?
52.
Let's 52, 53. All these three matters. 52, 53, 54, all provident fund matters. Milord, yesterday we mentioned, since your lordship has taken up one matter, milord, absolutely identical in nature. Perhaps only the charge sheet number requires to be changed in your lordship judgment. All payments made. 52, milord, I'll just.
Yes, what does the authority say?
The authority says whatever, my lord, they have been in 50, serial number 402.
402, the first matter.
Yes, 402.
And I am not getting any such challan from the, they have stated that.
No, no.
Where are the documents showing payment?
Milord, challan is not required. 402, milord, the challans are there in fact.
Where?
Milord, page 20 and 21. 2,71,000.
Sorry, Mr. Ghosh.
20 and 21.
It pertains to.
No, milord, I'll demonstrate, milord, payment has been made. Milord, but my only submission is, milord, whether payment has been made or not, milord, how this can be a consideration in this application. Because, milord,
No,
only,
cannot be a consideration,
milord,
but then.
only to demonstrate our bona fide, milord, we have said that the payment has been made. Irrespective of that, if it is due, they can proceed under 14B instead of pursuing these FIRs. But still, milord, for our bona fide, milord, page 20 and 21, milord would find the two challans. 2,71,811.
And 275, 330.
275.
These are the due amounts.
Yes.
No.
These are, milord, the due amounts, and the payment challan, milord, would find on page 22. 275,330. 330.
Two payments are shown,
Yes.
but even without the payments.
Yes. Even without the payments, milord,
14A is a bar.
14A is a bar. So they cannot insist for payment. You cannot use this FIR as a tool of recovery.
This is their bona fide.
No, because of the, this is the, under, actually this amount is pertains to the employee.
Maybe. Have you
Employee.
impleted the company? Have you impleted the
No,
company?
Yes.
That is the only issue.
So far, Mr. Ghosh's submission is concerned, I have no authority because of, I have the authority. Because he collected the amount from the employee.
He is the company, not the directors.
Company and director also, in course of.
Along with the company.
Along with the company.
Not without. It's
No,
not
no.
disjunctive.
During discharge of duty
The same order will be passed.
And milord, for Mr. Roy Mosha's satisfaction, milord, I'll just inform him that subsequently in 2023, in respect of this tea garden, one authentic tea company limited has been granted lease by the government of West Bengal. They have cleared all the area dues in respect of this garden. I am submitting this with utmost responsibility. I have seen the documents. You please verify. These dues are no more there. Authentic tea private limited.
papers.
I can give you the papers, but in course of the day, milord, for his satisfaction. That
Do you want to use a supplementary?
no, not required, milord, because the question of payment, milord, is absolutely irrelevant. For the satisfaction of your lordship, milord, I am submitting this. The payments are no more due.
I'm not reserving this. I'll pass orders by today.
Grateful, milord. As his
I'm not
lordship
reserving
wishes.
this. The same order will be passed.
As
I'm
lordship-
quashing this.
Yes.
With respect to the item number 52 and 53.
52, milord, that,
52, I'll take up one by one.
yes. 52, milord, has already heard.
Order.
So, you are submitting 52.
52 hai.
52 is complete.
Alternate counsels for the parties. बोले? 53 same?
53 same, my lord, the entire amount has been paid reflected from the order of the learned SCGM.
Yes.
This is at that time of.
Well, because-
When is in custody, that time there is a direction you go for payment. And then it has been.
That the entire payment was made, then the bail was granted.
The bill was granted. So,
52 same, interim is paid for 52, 53.
that is even
Total
not clear.
collage. 52 full land.
Which goes that,
53 same order,
53
quashed.
Yes, 54 my lord is same my lord. There is a, presently there is a due pertaining to the period 2014 to 16 as per their document, but the FIR pertains to 2011
There is
period.
a specific order. The order dated 26 November 2024
By this court?
by this court.
But this honorable court said, subject to payment of rupees, another rupees 4 lakhs,
It should be.
the warrant should remain state.
Oh, this should be compliant.
Now, my lord, today, my lord, your lordship is considering the application in its entirety. Now, my lord, whether what, if this honorable court has observed, my lord, I don't believe,
Give
my
your-
lord. Yes,
give
my lord.
Para number 5. That is specifically directed 2 weeks from the day. That should be compliant.
You have not deposited this amount.
No, because,
This is a court direction.
no, my lord, but,
Direction
my lord, the kindly appreciate, my lord. My lord, kindly takes page 29. Page 29 is the certificate issued by them, which was the basis of the order being passed. The order which your lordship has just said.
An order has been passed which holds the field, which
Right.
has not been assailed.
That's right.
So, and you have your protection till February 2025.
So, my lord,
So I'm sorry,
kindly,
in this matter, I will not.
Millard kindly takes it up on Monday. Millard will comply with this direction and come back. Subject to Mr.
Okay,
Roy Mosha's
not today,
satisfaction.
not today.
Not today, yes.
Not today.
Grateful. Then you can clear all the dues. Now 8 lakhs actually, Mr. Ghosh. That is been only 4 lakhs. You have to clear all the.
Next. Hi. Yes, 55.
I'm for the.
Yes.
My lord, because yesterday.
What is the order about?
My lord, the
And,
order,
There was a direction for service.
yes, my lord, I have. Affidavit in service was submitted by me yesterday.
Yes, it's Yes, what is this order impugned?
My lord, the order impugned is, my lord, the trial, the appellate court has reduced the quantum of maintenance provided to the petitioner and her ailing child. Unfortunately, my lord, yesterday the child died.
Oh, it's that matter.
Now, my lord, the series of orders which are here, my lord, if my lord comes to page 38, this is the first order passed by the learned court below. Page 38.
There was a direction for 11,000, right?
Yes, my lord. The earlier direction was, my lord, 4,000 for mother, 4,000 for the child, and 7,000 towards the medical expenses of the child, which was upheld by the Honorable Coordinate Bench of this High Court, my lord. That was the trial judge superseded his power and reduced that amount,
Why do you say-
7,000,
Why do you say superseded his power?
because, my lord, the 7,000 was upheld by the Honorable High Court. And the trial judge has reduced that 7,000 to
Where
3.
is the order of this court?
Yes, my lord. It is at page starting from page, my lord, 72. Operating portion is at, my lord, page 73.
Was there any application for alteration of the amount?
No, my lord. Thereafter, my lord,
You are appearing for the state, right?
My lord,
But the state has no role to play here. It's a maintenance case.
you have made us a part.
Normally they make, but actually the state has nothing to say in this matter. I'll request you to serve a further notice and come back. Since I'm minded to alter the position,
my lord.
please serve a further notice because now the situation is also precarious, right? The child has just passed away and the private opposite party is the father of the child.
Yes, my lord.
And I hope he has joined the last rituals, no?
Actually, he deserted the petitioner because of that child only. Since the child was born retarded, that was the main dispute, and he deserted the wife and the child. He is a primary school teacher, my lord.
Because I would like to also see whether there was any application made by the opposite party before the trial court.
Yes,
Or
but that
any
is the
changed-
order.
Any
That,
changed circumstance.
no, if my lord comes to the
Because
impugned
that
order,
authority was granted.
my lord, if my lord comes to the impugned order at page 95. Page 95, last, my lord.
Yes.
He filed an application challenging the impugned order dated 10th of June 2024. Passed by the learned Chief Judicial Magistrate Kujbihar in miscellaneous case number 54.
So there, this court dealt with the order of 2020.
Yes, my lord.
Order of 2024.
My lord, in that order only, that was sustained by this order, my lord. Same order was passed here also. If my lord comes to page 93, my lord. $8,000 and $7,000, totaling 15,000. Same order was passed, my lord.
10,000 and 5,000.
5,000. The quantum was same, 15. Now that was reduced to 11,000.
That is an interim reduction. The
Yes,
matter
my
is
lord.
pending.
Yes, my lord. He has stopped the payment, my lord.
And at the moment, you have to come back with a supplementary affidavit stating that you don't no longer require any amount for the child.
Yes, my lord.
So come back with a supplementary affidavit.
My lord, then grant me.
Time for responding.
Yes.
Okay.
My lord, today I take time. Thank you.
I'll grant in any event, you have to come back, you have to inform this.
Yes, my lord.
Because this will also be a change of circumstances. Isn't
Circumstances,
it?
my lord.
And the same thing should be informed before the learned trial court also. On prayer of the,
Unfortunately, my lord, I am unable to face them because the
I no,
situation.
no, let them, give them some time.
Yes, my lord.
Give them some time.
So kindly grant me some time, my lord.
Next circuit.
My lord.
On prayer of the petitioner, liberty is granted to use a supplementary affidavit. Learned counsel for the petitioner submits that the minor child of the petitioner has passed away on
19th of
19th December 2024. Paragraph on prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, learned counsel for the opposite part, private opposite party seeks accommodation. Paragraph, let the matter, the matter be placed for the next available circuit bench.
Deeply obliged. Deeply obliged.
Next.
56, I am for the petition, my lordship.
At the motion stage,
Yes, my lordship. Last previous date, the order was passed by the earlier bench, raising a question of maintainability of section 482 application if the accused is declared to be absconding. However, in the present case, the accused is not absconding. It is just the submission in the charge sheet by
give me a
the.
minute, please. Let me
Yes.
just go through this order, earlier order. The victim was represented, right? On the
Yes.
earlier occasion?
Yes.
Have you served the state?
Yes, my lordship. The previous date state took the date and kept it on 20th.
Mr. Shulkar Chettle, he's on his legs, number 1. I will inform him.
I'll pass it over.
Pass it over. He's on his legs.
A warrant of arrest has been issued, right?
Yes, my lordship.
A very short matter. Please inform me. Passed over.
So when I'm paying for next cycle, lordship, services. not-
Next circuit. On prayer of the petitioner, the matter be placed before the next available circuit bench.
Grateful.
I'll call these few matters and go back. Next.
58. 58 minute is a new motion. For Hudson. Bishop. What? Look, this impugned order, Millard, is an order where an application under section 10, Millard, has been allowed, Millard, in a mechanical manner. Millard, I say this because from perusal of the subsequent suit and the previous suit, it will appear, Millard, that the suit properties are entirely different, although adjoining plots, but the suit properties are different.
9th September order.
September 2024, Millard, is the impugned order.
Serve and come back. The suit is already stayed.
Suit is already not stayed, Millard, it's appearing for the first
The
time.
present suit is stayed. No.
The subsequent.
The
suit is-
trial court has done the job.
Trial court has done the job.
So serve and come back. It will be, it can be heard out. It has
Great,
to be heard as a contested application.
Yes.
The petitioner has assailed the order passed by the learned civil judge within bracket junior division, Jalpaiguri on 9th September 2024 in title suit 84 of 2023, whereby the learned court has allowed an application filed by the opposite party under section 10 of the Code of Civil Procedure. Paragraph, the petitioners are directed to serve copy of the petitioners have assailed forgery. Petitioners have. The petitioners are directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench.
Grateful.
Next.
59.
Clear, lordship, and for the petitioner, lordship, there's a direction for filing a supplementary affidavit, lordship.
Is service complete?
And for the private respondent.
Lordship,
Yes, a question was raised by this court as to whether you filed your affidavit of assets and liabilities before the trial court.
Yes, that was for the petitioner.
No, for the opposite party also.
Opposite party, my lordship.
You were unable to apprise the court as to whether your affidavit was filed. And you wanted to take necessary instruction on this. Please see the order dated 27th November 2024.
So far, my knowledge, there was no assets and liabilities application was filed. Affidavit was filed.
Yes, 29th August order you've challenged.
Yes, Lord.
Yes,
Lordship, if your lordship kindly fixed on this matter on Monday.
Monday will
Yes.
not be possible.
But it is be short matter, lordship. It is a matter
No
of
further
enhancement of
matters on
the
Monday. Monday only the list of matters that are already in the list will appear on Monday.
lordship.
No further
Actually, lordship, learned senior counsel will appear.
Next circuit.
Kindly
My
on Monday,
my
lordship.
lordship, only prayer should, my request is that if we go through the prayer, they are just asking for setting aside the order.
29th August order. He is not ready with the brief today. I cannot deal with it.
Lordship, this is a very short matter, lordship. Kindly
So
fix.
why aren't you prepared if it is a short matter? Why are you waiting for your senior? If it's a short matter, mention, make your submissions, I'll consider.
Lordship, actually, this is the matter of the petitioner file a petition for under section 36 of Special Marriage Act for maintenance, lordship. The maintenance was granted by the learned trial court, lordship, but the maintenance amount is very low, lordship. That's why we come before this court, lordship.
Have you asked for enhancement?
Uh,
No, my lordship, there is no prayer. In fact, in the assets and liability affidavit, my lordship, if you peruse the assets and liabilities affidavit, her requirement is 3,000 to 5,000.
You are praying for setting aside the order and staying the suit.
That's what.
Where is your prayer for enhancement? Your verbal prayer is for enhancement, right?
yes, yes, your lordship.
You say that it's a very meager amount, it has to be enhanced, but where is the prayer?
In fact, in the assets and liabilities affidavit, her needs is only 3,000 to 5,000, she has mentioned there. And the order allowed is 6,000 rupees.
Next circuit, let his senior come. He is not prepared. Supplementary affidavit filed by the petitioner is taken on record. Paragraph on prayer of the petitioner, comma, the matter will be placed before the next available circuit.
Obliged.
Next.
Number 16.
Service complete.
Yes, ma'am.
What is the can about?
My lord, the revisional application was disposed of, wherein the learned court below was directed by the court to pass a reasoned order within 30 days. After 15 days, which the petition opposite party were to file WO. After the order was passed, the same was communicated by way of a put-up petition before the learned court below. My lord kindly takes that order. My lord, without giving effect, my lord, the same order that was challenged and set aside has been given effect, my lord. My lord kindly takes page number 9 first, my lord. After hearing both the parties, the instant application is disposed of with a liberty to the respondent to file WO, preferably within 15 days from date against the application. My lord, the number is mistaken. And the trial court shall dispose expeditiously the application for custody and guardianship of minor, preferably within 1 month. My lord, this was passed on 11th November. My lord, then on 12th, there was certain mistake, my lord, that was corrected. The section was mistakenly put, my lord. My lord, thereafter, my lord, kindly sees on 14th.
Give me a minute. Could you serve the opposite party?
I have served,
Her
my lord.
presence is required.
My lord, I have served. It has been delivered, my lord.
Yes, it is delivered.
My lord, I am just a father who wants to meet my daughter. And my lord, for past 1 year, for different excuses, my lord, they have even given a affidavit with false statement, my lord, which by the way of affidavit itself is shown that it is false. The affirmation of affidavit is made in Shiliguri and they are saying I'm at Alipurdwar.
And the application is still pending.
My lord, this was disposed of with the direction that this lower court was to pre-fix the matter. But my lord, again, the matter was fixed on the same date it was earlier directed, my lord, without giving effect to the order
This
passed
is
by.
an 11th November order, right?
Yes, my lord. My lord, it was put up on 14th 11, my lord, that is at page 11.
What is your prayer
My lord, in this application,
in the present?
my lord, since I'm suffering, my lord, I want a scheduled visitation of my daughter, my lord. Till
But
the,
that is the application which is pending already, is
but
it?
my lord, it is being,
Where is the last order? Your application, your revisional application is
was
very vague.
disposed of.
No. The present application.
My lord, I'm just seeking the implementation of the order passed by this honorable court, my lord, by,
Where is that prayer seeking implementation of the order?
my lord, kindly takes my prayer, my lord.
Or to
Pass an
comply
appropriate-
with the directions,
Yes,
yes.
my lord.
And where are the orders of the trial court?
My lord, it is with the revisional application, my lord. May I kindly show?
No, after 11th?
After 11, my page number 11. That is the only order that has been passed. Wherein again, the date that was fixed earlier has been fixed.
Page number 11.
Yes, my lord. Annexure C. Of the CAN application.
Oh, so that.
Last page.
This order was passed in presence of the respondent.
They are doing this dilatory tactics, my lord, so that I am suffering every day. My lord, innocuous prayer today, my lord, Christmas and New Year's are at the word, my lord. If I was given an opportunity to see my daughter, meet my daughter, since birth I have not seen. She has deserted me since the birth of the child.
Which court is this?
My lord, the additional
Judge,
district
Special
and
Court,
sessions judge
Boxer.
at Shiliguri. First court, Shiliguri.
Now, the other side is also not there. If the other side would have
They are
been
doing
there.
this, my lord, deliberately, my lord. I do not make such comments, my lord, but this is completely deliberate, my lord, to
Well,
further
Pastor,
prejudice my rights.
I'll ask the court to dispose it of immediately. Affidavit of service. Paragraph, none appears for the opposite party despite service. Paragraph, heard learned counsel for the petitioner. Paragraph, the petitioner is the husband of the opposite party. And the couple is blessed with a child who is a minor. By an order passed on 11th November 2024 in CO 188 of 2024, a coordinate bench of this court directed the learned trial court to dispose of the pending applications expeditiously, preferably within 1 month after filing of written objection by the opposite party, which was directed to be filed preferably within 15 days from the date of the order. Paragraph. Learned counsel for the petitioner submits that such written objection was not filed by the opposite party in compliance with the direction of this court, and the learned trial court has refused to prepone the date of hearing of the applications. Paragraph. since the order dated 11th November 2024 was passed by this court in presence of the opposite party / his representative, comma, his authorized representative, comma. There was no reason for the learned trial court to serve further notice upon the opposite party before taking up the applications for consideration. Stop. It is evident that the opposite party failed to file written objection before the learned trial court within the stipulated time frame. The innocuous prayer of the petitioner, who is the father of the child, is for a visitation right in view of the ensuing Christmas and New Year. Paragraph. In view of the above, comma, this court directs the learned trial court to dispose of the pending applications as referred to in the order dated 11th November 2024 passed by this court in CO 188 of 2024 within two weeks from date. Stop. Since the opposite party has refrained from filing any written objection before the court till date, comma, it can be safely held that he does not intend to file such written objection. She does not intend to file such written objection. She does. Paragraph with the aforesaid observation and direction, the divisional application being this is your prayer in the can, right? The CRR will remain pending. CO 188 was disposed of. Can 1 of 2024 is allowed. Urgent 75%. Next. 61.
Hello, sir. Appearing on behalf of opposite party number 1, my lords.
That
My lords,
is
if my
recording
learned
that you
friend,
are being.
my lords, if my learned friend would turn on the mic, my lords, I cannot hear him.
What is the stage of the suit before the trial court?
So it is fixed for evidence. I have already filed my affidavit in chief, but respondents are continuously taking time.
The divorce suit is at your instance.
Yes.
You are the
Yes,
petitioner there.
it is in my instance. I have filed my affidavit in chief, but they are not cross-examining me.
How many witnesses do you want to examine?
Only two witnesses, I myself and another witness will be there.
Yes, he is seeking expeditious disposal of the divorce suit.
My lords, I'm not against that, my lords, but my lords, they have not come before this honorable court, my lords, with clean hands. My lords, may kindly see the last order, my lords. Dated, my lords, 29th of November.
What does that have to do with the expeditious disposal?
My lords, may kindly hear me out, my lords.
Yes?
My lords, they are seeking
What is the
expeditious hearing,
nexus?
my lords. My lords, on the basis of the fact that they have not, on the basis of the fact that they have filed their entire arrears, my lords. They have not paid a single copper, my lords, towards arrears, my lords, till date. From my lords,
The money received.
from the date of filing of
Does
my
that
application under
justify
section
delaying the
24.
disposal?
I have not delayed, my lords. My lords, may
There
also
is any
kindly see the
outstanding,
amount
I
of
will
time
pay.
petitions that they have filed.
I am paying, and the last payment was made in the year, in the month of December itself. 30,000 was paid.
My lords, let them file,
If there is
let them
any
file an
dues,
affidavit, my
and
lords, then
it may be
detailing the areas
calculated
that they
and
have
I will
filed.
pay.
Because, my lords, my client has not received a single copper, my lords. Let them file an affidavit, my lords, detailing the areas.
Please come back with a supplementary affidavit.
My lords, I'm
And
great.
exhibit the documents.
That's why I am paying.
Because that was in fact the observation of the
And my
court.
lords,
That
they
is
have
not
also suppressed the
corroborated by any
fact,
statement. So you have to
my
come back
lords,
with the documents.
my lords, they have also suppressed,
He wants to see whether he says his client has not received any amount.
It is received by.
from my lords,
Sujata Burman is the client, isn't it?
Lordship.
yes, my lords.
It bears the signature of your client, the documents. Come back with an affidavit.
Lordship.
Next
Kindly
circuit.
fix the matter on Monday.
Next circuit. No further proceedings.
My lords, detailing the areas that they have paid, my lords.
Yes?
Detailing the areas that they have paid, my lords,
I
in
am
the affidavit.
paying the amount. If there is any
Please
dues.
serve a copy to him. He is denying payment.
Lordship.
So please serve a copy to him. Let him find out.
Lordship.
On prayer of the petitioner, liberty is granted to use a supplementary affidavit showing annexing documents with regard to payment of the entire arrears towards alimony pending delight. Paragraph, the matter be placed before the next available circuit bench. Please give him an
My lords,
advance.
and
notice so
reply,
that the
my
matter
lords,
can be dealt
liberty to
with.
file reply, my lords.
Yes.
Liberty to file reply, if any, reply, my lords. Liberty to file reply to the affidavit, my lords.
On prayer of the on prayer of the opposite party, comma, liberty is granted to use a reply to the affidavit, comma, if required.
Grateful.
I'm so grateful, my lords.
Next. Yes.
My lord, 64, I put the petition.
Yes.
Is this revision against the order passed by the subdivisional magistrate in connection with maintenance and welfare of parents and senior citizen 2007 Act. My lord, the opposite party is my mother, and she claims maintenance as well as the occupation right over the property. And the dispute has to go before the subdivisional magistrate. Now, lordship kindly to the order impugned. Order dated 13th. Order number 13.
29-8.
Lordship. A report has been called for from the BDO. BDO has been submitted the report in respect, but nothing has been stated in the report. But the impugned orders suggest, my lord, can I read that?
Yes.
My lord, both appears before the tribunal and Hajira through learned lawyer heard the parties in details. Peruse the report submitted by the BLRO Matigara, wherein it appears that plot number such and such or moja such and such with 73 decimal appearing LR Khotian number such and such is lying record in the name of Lalu Burman by means of Patta deed, and said Patta holder Lalu Burman is not authorized to transfer any part of the said land by means of sale or otherwise as per provision of section 49 of WLR Act. Get it, my lord? But in the instant case, it appears that the said Patta holder transfer portion of the said land in contravention of section 49 within bracket 1 capital A of say WLR Act illegally, which attracts penal provision like annulment of the said Patta. Third paragraph, from the report submitted by the BDO Matigara dated 1st August 2024, it appears that Vishwajit Sarkar, the OP number 1, occupying the plot illegally and running a garment shop of the said plot, which was earlier settled to the said Patta holder. On hearing both parties, it appears the following. The applicant has two sons, namely Vishwajit Sarkar and Prionath Sarkar. The said O.P. Bishune Sarkar lives in a separate constructed house over the another plot of donated by his father late Brojobashi Sarkar, and Bishwajit Sarkar, O.P. number lives in the said plot at Kawakhali area with his family members. The said late Brojobashi Sarkar donated the huge quantum of land to their two sons, namely Bishwajit Sarkar and Prionath Sarkar. The applicant lives in a rented house separately at a month rent of 2,200 in a separate premises. As per statement of applicant during the hearing, she does not require any maintenance amount for the at present. From the report submitted by the different inquiries officer on the facts delivered from the hearing of the both parties, I am satisfied to hold the following along with the observation. Bishwajit Sarkar, OP number 1 is occupying illegally and running business on the suit which was earlier settled in a patta holder of OP number 1 has procured the said land illegally in contravention of section 49 within bracket 1 capital A of WBL Act. The illegal occupation of the said land of the OP number 1 is required to eviction. Hence, BLRO Matigara is directed to start annulment proceedings under section 49(1)A of WBL Act accordingly for eviction of the OP number 1 thereafter. The applicant has no right to get back restoration of this land under the possession.
Applicant is the opposite party. You are not concerned.
No, I'm on the
On this repeated issue, yes.
no other issue of maintenance stands. Applicant herself does not want at present having no other issues to decide further under section 14(49)A, the maintenance and welfare parents of senior citizen disposed of. Now, my lord, the act, the subdivision magistrate acted upon this act, and so far within the act he has to deal with whether maintenance or the as per the case of the OP number 1, I am the occupying or not. But on discussing this act or dealing with this act, the subdivision magistrate entered into another jurisdiction which is absolutely not within the
Because this is where is the application made by the opposite party?
that has been application is annexure, lordship, annexure P1 14. There is no such whisper about that fact. And the prayer is 19, page number 19. Prayer is 19. Page number 19. My lord, get it?
Yes.
Admit the application, pass necessary order directing OP number 1 to pay say sum of ₹20,000 per month applicant for her maintenance. Also further necessary order to evict the opposite party and their associates from the aforesaid land house and shop of the applicant. It is this stated the land which is occupying by me evicted him and restore his possession.
So
Here,
there is a prayer.
prayer.
It's not that he has gone away from the prayer.
No,
He has dealt with the prayer.
lordship, so far prayer is concerned, my lord, that has been within regards to that she wants to get back his possession. In this impingement order, the order itself is there stated that BLRO is directed to annul the possession patta and evict me from the land. Not that they restored the OP number 1.
That is a different part. There are two aspects.
Lordship.
One is eviction, the second is restoration.
Restoration.
So there is nothing wrong with the eviction order. I would request you to serve and come back.
Lordship, kindly, in the meantime, I will be evicted.
No, you will not. You will not, because if this proceeding is initiated, you'll be served notice.
Lordship, kindly see only that one. He is a 49A, he is empowered. This subdivision magistrate, because of this is absolutely on the periphery of the BLRO. How can directed the BLRO to start initial proceedings, lordship? Because of this is the only the act is only.
Since it is the domain of the BLLRO, the subdivisional magistrate has directed the BLLRO to deal with the matter.
Within the WBL Act, lordship, not this is within the maintenance of welfare.
That's why he has not dealt with this. He has
That's-
asked the BLLR to deal with it under 49(1)(a).
Lordship, not heavy, and therefore, and so also order that the applicant has no right to get back restoration and land possession as paid for as it is not tenable in the law. The from the report, it is some different inquiry officer on the fact of the hearing on the both parties. I satisfied holding the following the Vishwajit Sarkar. OP number 1 is occupying illegally and running business on a suit which was the earlier settled patta land holder, and OP number 1 procured the said illegally contravention of the section 49(1)(a). How can 49(a) comes into this point? And therefore, and the illegal occupation of the land by the OP number is requires eviction. Then Lordship, that is hence BLR Matigara is directed to start annulment of under section
The
proceedings.
proceeding has not been initiated as yet. Has it been initiated? Have you? received
Lordship,
notice?
I was under threatened by the BLR official. Go and evict evict the dispossession over the property immediately.
Very well. I'll stay this order for the time being.
Timing, Lordship.
Please serve and come. The petitioners are aggrieved by the order passed by the learned subdivisional magistrate, Siliguri, on 29th August 2024 in Miss Petition Case Number 1 of 2022. Paragraph, learned counsel for the petitioners submits that the opposite party is the mother of the petitioners,
My mother.
who is the mother of the petitioners, filed an application under section 4/9 of the Maintenance and Welfare of Parents and Senior Citizens Act, 2007, along with a prayer for interim maintenance under section 5 within bracket 2 of the Act. Stop. By the order impugned, the subdivisional magistrate has recorded that the first petitioner is occupying the property concerned illegally and has directed the Block Land and Land Reforms Officer, Matigara, to initiate proceeding under section 49 within bracket 1 capital A, 1A activity of the West Bengal Land Reforms Act. Learned counsel submits that in an application under the 2007 Act, in dealing with an application under the 2007 Act, the subdivisional magistrate had no authority to hold that the first petitioner is occupying the property illegally or to direct the Block Land and Land Reforms Officer to initiate proceedings against him. Paragraph, it appears on perusal of the record that the matter needs to be heard on merits. Paragraph, the petitioners are directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the adjourned date. You have to implead the subdivisional magistrate also. The state, at least.
State is because of this is the private dispute.
Maybe, but the order is you're challenging an order of the state. The subdivisional magistrate.
Subdivisional magistrate is a.
Because here the opposite party has nothing to do.
He had to only to submit the either correct or not. His order actually not correct. It's as per law.
So in that case, you have to implead the state also.
Kindly take.
opposite parties score. And file affidavit of service on the agenda, paragraph, the matter be placed with the next available circuit bench. Agno Shurute Koror on prayer of the, since the order is by, on behalf of the state.
Lordship,
So the state is a necessary part.
Lordship.
Agno Shurute first line Koror on prayer of the petitioners, liberty is granted to impede the state of West Bengal as opposite party number 2 in the application. Stop the cost settle of the application be amended accordingly. The petitioners are directed to self copy. Oh, it is self copy বলেছি আমি। হ্যাঁ। পরে বলছি।
Lordship, try still, Lordship, still, only limited period.
Yes,
Still,
yes.
Lordship.
The place before the available circuit bench তার আগে করুন। তার আগে করুন। The order impugned dated 29th August 2024 passed by the learned subdivisional magistrate, Siliguri in Miss Petition case number 1 of 2022 be stayed till 31st January 2025 or under further orders, whichever is earlier.
Deeply obliged.
Next.
Lordship, I pay for 1 day accommodation, Lordship.
Not today.
Lordship.
Next.
Sixty-four is Millard, my application Millard against Millard, an order passed under section 24. Millard, I am the husband. Millard, despite service Millard, the opposite party is not represented. On the earlier occasion also Millard, they were not represented. Millard, my only limited grievance is Millard, a substantial amount has been Millard awarded. Millard, without even prima facie ascertaining of the income as shall Millard expressly appear from the order. Millard, I say Millard, despite having the affidavits of assets on record, the landed court ought to have at least recorded a prima facie finding as to what is the income of the husband. Without doing that, Millard, kindly cease Millard. A substantial amount Millard has been directed to be paid to the wife Millard to the tune of 75,000 per month.
14 June order.
Absolutely right. 14th June 2024.
I beg that it will be up to the opposite party. I'm
Yes.
praying for a time.
So I'll pray for a limited stay of this order. Millard, kindly consider that. Millard, absolutely bad in law. At least Millard, a prima facie finding as to the income has to be there. Millard, I am a person, Millard, who is vending this pan masala and tobacco products from shop to shop. That is Millard what I do. I'm
You have declared your monthly income to be 50,000.
Then Millard, how can I pay 75,000? Even if I accept that to be gospel truth, the court has to also take into consider the expenses. Let that not be done. Even if it is 50,000, as per my declaration, how can I pay 75,000?
Oh, seems to be earning 3 lakhs per month.
Seems to be. But what is the material on record? The affidavit of assets, Millard knows after Rajesh versus Ne, it is mandatory. The court has to go by that. Seems to be earning 3 lakhs per month. What is the material in support of this finding? All Millard preponderance.
The main matter is still pending, right?
It is pending, it is pending.
Stay at the moment. Let him come back, deal with it. Can the matter
But
be dealt with?
Millard, I have to pay something. I know she's my wife. Until and unless the marriage is dissolved, I have to pay.
Are you paying any amount?
No, not yet. Because this I cannot pay. Millard directs me to pay a reasonable amount. Millard, I will do that. By that time, Millard, let this order be stayed for some time. I cannot shun my liability to pay. I am not on that. I cannot.
Wait for 7 days. Let him appear. Let the court deal with it and grant us.
Great.
Because the next circuit is on 2nd.
Second.
So you don't have to wait for long.
If Millard kindly Millard passes one line order so that it at least appears in the
I will.
list.
Affidavit of service. Paragraph, learned counsel for the respondent, opposite party seeks accommodation. Paragraph, the matter be placed before the next available circuit bench. Next.
I'm for the appellant.
What is the application
Second
about?
appeal, my lord. It's a condonation of delay application, section 5.
Have you served?
Yes. My lord, I've specified the grounds of the delay in paragraph numbers 3 and 5, 3 and 4 of my CAN application. And there's a delay of
Oh,
15
there are
and-
many respondents.
Yes, my lord, that's up.
24 of them. Have you served all of
Yes,
them?
my lord. Believe those been served.
Anyone appearing for the respondents? No one. I'll condone the delay. I'll
Lordship.
condone the delay. This was of your, you filed a separate application for delay?
Yes, my lord, CAN 1.
That's CAN 1.
Yes.
Affidavit of service, none appears for the respondents despite service. Paragraph, the appellants seek condonation of delay in preferring the appeal. Paragraph, good grounds being shown, comma, the application is allowed. Paragraph, delay in filing, how many days delay?
1532, my lord, including the COVID period, my lord.
Delay in preferring the appeal is condoned. CAN 1 of 2024 is disposed of.
Grateful, lordship.
Next.
I'm for
Yes.
the affidavit, Lordship. This is a motor vehicle MSCC case, Lordship, with a delay,
Delay is there.
small
Ser-
delay,
Served. Small, big, there's a delay.
not sir,
Not served.
not sir.
You filed the application.
Yes, yes.
The petition, the appellant, the appellants, there are two appellants. The appellants are directed to soft copy of the application under section 5 of the Limitation Act upon the respondents and file affidavit of service on the agenda date. Paragraph, the matter be placed before the next available circuit.
Lordship, can it be taken up on Monday or Tuesday?
No,
or
because it has to be heard. The entire matter has to be heard.
It can be
Can't
admitted.
be Monday, Tuesday is the last date. This time, it's difficult. 1 whole week we could have considered. Next. Yes, sir.
Kindly put this matter to next circuit, my lordship.
On prayer of the appellant, the matter be placed before the next available circuit bench.
Grateful, my lordship.
68. None appears for the appellant, no accommodation is sought, the matter is placed, the matter be placed before the next available circuit bench.
Lord,
The passed over
my lord,
matter.
my lord,
20.
Lords, I am led by Mr. N. Bhattacharya virtually.
Is there? Yes, Mr. Bhattacharya. At the motion stage? Yes, Mr. Bhattacharya. Neither audible nor visible. Where is he? Not today.
Your lordship, am I audible, lordship? Hello, your lordship.
Yes, Mr. Bhattacharya, are you there?
Your lordship, I'm Mr. Oyan Bhattacharya's chamber junior. Can the matter be taken up at 2 p.m., your lordship?
Not audible.
My lord, can this matter be fixed at 2?
Other matters, so I cannot fix it. I'll make it not today.
My lord, not today, my lord, it will go up again, my lord, on 23rd.
Yes. Can't help. This is the second call.
My lord, he is on phone, my lord, may I tell him, my lord?
What
Yes.
will you tell him?
To appear, my lord, I think there is.
He is there, there's some technical glitch, he's not
Yes,
able
yes,
to
my lord,
appear.
that's why, my lord, a short password maybe, my lord.
No second passover.
Second
have
passover,
other
I
matters
know,
that
my lord, that is, yeah.
Not possible, not today. Next. Thirty. Thirty. Yes.
I'm put the petition.
Yes.
I have filed this application under section 482 of the Code of Criminal Procedure, Lordship, for quashing of the proceeding, Lordship. Lordship, the state is required to add out the matter.
You have not served, have you served?
Served, I served. It's ready to, I have served to the defect complaint also, which is the evidence service.
Anyone appearing for the state?
Lordship, kindly make 1 day accommodation, Lordship, kindly 1 day accommodation,
This matter?
this matter.
Or has the private respondent been served?
Yes, I served.
Where is your track report?
Lordship, I.
Oh, it's served. It's served. Not today. Give this to me on Monday, please.
Lordship.
Eta fero diye din. Not today.
Great.
Monday, there will be no Passover.
Okay, Lordship.
Next, 31. No one. None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench. 42.
I am for the state.
42, I beg to appear for the petitioner. Lord, in
Yes,
this
42.
Yes, my lord, in this matter, my lord, that problem arose, my lord, with the section 180 being charge sheeted and cognizance being
Yes,
taken
you
without.
already.
Yes. Lordship, actually the crux of the allegation is that a patient was admitted, the de facto complaints relative was admitted there, and they prayed for a Shastro Sathi card, but the nursing home authority refused it. Though Shastro Sathi is regarding the issuance of admission of Shastro Sathi card, there is a government order, but here it's true. I am fairly admitting that
The complaint was not filed.
not filed by the public servant. But now, Lordship, here there is two part of the FIR. On the first part, they came for submission of Shastro Sathi card and that was denied. This is one transaction. Now, the second transaction is when they again went to with some NGOs, when the de facto complaint in NGO member went to the counter, the de facto complaint, who was a lady, was called inside the room, and the muscleman was sitting there, and where her modesty was outraged. This is not the part of the same transaction, Lordship. At the first transaction, prayer for Shastro Sathi card, that was denied and 30,000 rupees was deposited. The first transaction is over. Now in the second transaction, this is not a part of the same transaction. So in the second transaction, when she again went there with NGO members and prayed for.
Have you filed two separate charge sheets?
Lordship, the case arose of a single PS case number. So obviously,
They are not different transactions. It's a chain of transactions.
Lordship, may I be permitted? I am being a student of law. I am asking the question to myself. The decision which they have cited, and on the basis of the decision was the decision of Durgacharan Naik and others versus State of Odisha. Page 8 of the citation.
You gave it to me yesterday, right?
My lord, I have given that.
Do you have another copy? I find a coordinate bench's decision.
Yes, my lord, that is.
Within that decision.
Durgacharan Nayak, my lord, I have that another copy.
Not necessary, it's stated here.
It's stated there, paragraph number 8, my lord, if your lordship would kind enough to take the judgment of Durgacharan Nayak, my lord, I have that.
Paragraph 8.
Paragraph 8. Lordship, may I be permitted to read? In this context, the apex court in judgment Durgacharan Nayak and others versus State of Odisha reported in AIR 1966, Supreme Court 1775, was pleased to hold that now in the version, we have expressed the view that the section 195 of the Criminal Procedure Code does not bar the trial of an accused person for a distinct offense. Does not bar the trial of an offense for a distinct offense disclosed by the same or slightly different set of facts, which is not included within the ambit of this section. But we must point out that the provisions of section 195 cannot be evaded by resorting to devices or camouflage. Here there is no question of camouflage in this case, Lordship, because a lady has been ravished. A lady has been ravished, and this is not a minor offense than section 188. Because, for instance, the provisions of the section can be evaded by the device of charging a person with an offense to which the section does not apply, and then convicting him of offense to which it does, on the ground that the latter offense is a minor. Here, in this case, the basis of the judgment, the coordinate bench which passed the judgment, I am distinguishing the mother judgment is Durgacharan Nayak, where along with section 188, another section which was incorporated, that was minor. But here in the case of 188, the punishment prescribed is far less than the punishment prescribed under section 354 of the Indian Penal Code. So it's a major offense, Lordship. It's a major offense, and 354. Lordship has rightly put a question whether they are the chain of a same transaction or not. This cannot be a chain of a same transaction, Lordship, because I can refuse Sastha Sati card, then 188 will crop up. 188 will crop up. Whether now it will lie on or it will stand or not, it will not stand. That depends on who is lodging the complaint. If the public servant does not lodge the complaint, then 188 automatically evaporates. But section 354 does not evaporate because it is not a minor offense, Lordship. The principal judgment on the basis of which the coordinate court bench passed, and moreover, if your Lordship kindly take the pain to the basis of the coordinate bench judgment, where the 4 cases were registered, and the 4 cases were clubbed, and where 188 along with 447, there is a trespass, and that's why. That's why it was also a minor offense. But here, 354 is a major offense than 188. So this cannot, the coordinate bench judgment does not lie in this case here, Lordship. Because 354 is not a minor offense than 188.
Yes, how do you reply to this?
My lord, the contention of my senior that 354 is not made in the same transaction, my lord, I humbly submit that, my lord, if your lordship would kindly see the statements in Annexure C, page number 19 to 22 on.
This says the later offenses are lesser offenses,
My lord.
which is a camouflage.
Which is no, my lord, that is not, my lord, is not what it says. My lord, I can put up any ingredient, any allegation in a same transaction to bifurcate the process of 195, because this cannot be done. 195 usually does not happen in these types of cases. Now, my lord, I don't state anything in
195 primary, 188 primarily
evaporates.
Prima
That
facie goes.
Yes, my lord.
But 354
Yes, that's what I'm submitting, my lord. That I can submit I can put any allegation. Now, my lord, in the charge sheet, it has to be seen if that has any legs to stand or not. My lord, kindly sees the statement. If there is one whisper about 354.
Lordship,
this cannot be the case where the prosecution comes before the trial court and states, because there will be nothing to corroborate with.
Lordship, that is a matter of trial.
I will, sir, you will reply, sir. And my lord kindly considers the judgment, the whole thought process behind this judgment of Durgacharan Nayak, and later on reiterated before by the coordinate bench. My lord, that was the reason that these kinds of camouflage are used to bifurcate this process. My lord, that's why this was done.
Statements say dhakka diye ber kore deয়. That is
Lordship, even pushing comes within the ambit of section 354.
Intent.
Even pushing. Intent. Lordship. Yes, Lordship.
Let us read it once again.
matter the BL.
The old act.
Old act, old. Act.
The language,
Means, sorry.
it is assault or criminal force.
These dhakka.
Definition is 351.
Every day there would have been lakhs of 354. If
Maybe.
dhakka was 354.
Lordship, Lordship knows far better than me that Lordship is hearing under section 482 of the Criminal Procedure Code, where there will be a prima facie. If the case continues, there will be a prima facie miscarriage of justice. Regarding 351, assault, in each and every assault, your Lordship knows far better than me, there is a force. When there is a force, there is an assault.
No.
It should be a criminal force, not a. Not
Obviously, I went to the counter. Went to the counter. They now Lordship kindly consider the intention. They called inside the counter where the FIR clearly stated the musclemen were sitting there. The musclemen were sitting there, and they.
Even if dacoits were sitting there, there has to be a 354.
Yes, even if a lady sustained any jolt,
161 statements say.
all the 161 statements may not be annexed here. All the 161 may not be annexed here. Lordship,
Have the case diary with you?
no, Lordship, for that reason, I require a case diary, whether there is a medical document or
No,
not.
my lord, the charge sheet is there, my lord. No other 161 is there, my lord.
Medical
and medical is not required. Your lordship has expressed your lordship's mind on the last occasion that case diary would be required only on the point of
My brother,
maintainability, my lord.
I have the right to argue.
Yes,
You know, you cannot curtail my right to argue.
No, sir, I'm sorry, sir. We excited, really, sir.
Yeah, no, excited.
My lord, the charge sheet is here. No more 161, nothing. My lord, the charge sheet
Medical report may be there.
is more clear than that. And now, my lord, the counter case is also there. This advocate and the NGO staffs who went there, they actually committed this offense. My lord, your lordship knows what happens in these kind of situations, my lord. When they are told that they have to pay the bill, my lord, they do this all sort of things. My lord, I don't want to go into that, but my lord, kindly takes, if your lordship would take up.
No, I'm only on 354.
Lordship, my submission is whether the 354 will lie or not lie, that is the matter of trial, not at this stage, Lordship. Because there is a specific allegation.
Bhajan Lal says prima facie.
Yes.
Lordship, but there is a specific allegation in the FIR that there was a criminal force was.
Where is the allegation in the FIR that there was a criminal force?
So accordingly, we are told to go inside the chamber where some musclemen or staffs are sitting, whoever very arrogant, abusive. Even abusive comes within the ambit of section 354. Even abusive.
Yes, sir. But the criminal intent has to be separately established, my lord. Your lordship knows it better. Sorry.
Even stalking comes within the ambit of section 354. Follows women, contacts or attempts to contact such women.
I would like to see the criminal intent, prima facie. I'm not on trial.
Yes, prima facie. The FIR itself speaks arrogant, abusive, racial towards me and other accompanied members.
There is no allegation under the SC/ST atrocities.
Yes, that has also been stated.
No allegation, no charge sheet.
A poor scheduled caste people.
No charge
in the charge sheet, in the charge sheet. But at where the FIR is concerned, FIR is not an. I believe there is not an encyclopedia of it.
If you still want to come back with your CD and other documents, you can. Since I'm minded.
Yeah, Lordship kindly fixed it on. When is it Thursday?
Lord,
Wednesday, Thursday.
No, my lord, there is no certificate. My lord, my problem is, my lord, I will leave Siliguri tomorrow, today night, my lord, for my father's treatment in Tata, Kolkata, my lord. I will not be able to come back, lord.
Let him come back because this will be a
the next circuit.
because this is yes.
Next circuit.
Next circuit.
My lord, takes it up, my lord. Then your lordship takes it up, my lord. Then, my lord, the whole purpose of this hearing, my lord, will go to my lord.
No.
Your lordship knows, my lord.
Next circuit.
My lord, kindly.
If he wants to come back, with you.
Next.
I'm minded. I do not want to pass an order which will be difficult.
Then, my lord, on
তো
Friday.
ওটা পরে বলছি তুমি তুমি আদালতের সামনে যাও ওই আরো সময় করে মোশনের মামলাটা নিয়ে কথা
On 25th, my lord. On 24th, my lord. On 24th.
আনিস এসছে একটু আনিসের সাথে অ্যাটাচে যাও ওই কোর্ট মোশন মামলাটা নিয়ে কথা
Last day
বলবো
of the circuit, my lord. Tuesday. No. My lord, why I say this?
I have to pass an order.
Yes. Then your lordship can
Judgment.
CA with
No. I sit with 500, 600, 700
I know, my
matters
lord,
per
that your
day.
lordship is
in the
overburdened, I know.
Yes, Lordship, yes.
I will not carry matters from here. Let me be very frank.
Lordship,
My lord,
in case
my
of
lord,
item number 56, yeah, Lordship,
my
yeah.
lord, only one mentioning, I was mentioning in the morning, my lord, your lordship would recall, but due to some technical glitch, my lord, I could not mention.
Then, my lord, one more thing, my lord, I have to submit, my lord, I have to submit, my lord.
Paucity of time intervenes. Paragraph, the matter will be placed before the next.
My
scheduled
lord,
circuit.
I need a stay, my lord. Can't be, my lord, in this matter, I'm not enjoying a stay. My lord, your lordship sees
You are
what
on
has.
bail.
On bail.
I'm on bail, but my lord,
Which
the
has
lower
been
court break is
submitted.
there, my lord.
Let
My
me
lord, the
file
next
it.
day,
সেটাই হবে,
my lord, the
আমিও
next date
সেটাই
is on January, if I'm not too wrong, my lord.
Contested hearing without the.
আচ্ছা
My
আচ্ছা
lord, he's here, my lord, the stay may be.
I don't have the case
Your
diary.
lordship has stayed.
Without hearing him.
No, no, Lordship.
My lord, here.
This is not at the motion
This is
stage.
not
যদি
at
আছে হ্যাঁ হ্যাঁ হ্যাঁ
He doesn't have the case diary. I
ঠিক
cannot
আছে।
grant a
Case
stay.
diary, my lord, stay
When is
cannot
the
be
next
granted.
date?
একদম একদম তো ওটা কি আজকে নিয়ে
I'm
এসছো
not too wrong, my lord, 17th of January, my lord.
Some second January.
ঠিক আছে ওকে
Circuit is starting.
I have done.
My lord, I will
বাবিদের সাথে দেখা
not,
হয়েছে বাবিদা
my
গেছে
lord, I will not be here, my lord. I know, my lord, I will not be here, my lord. I will be in
ঠিক
Kolkata.
আছে
I
ওকে
know, my lord. I have a,
How long?
my lord, his radiation, my father's radiation therapy
Yes,
will
but
be
I
there, and
understand, but for how
1
long will
month
you be there?
continuously, I have to stay there, my lord. I
So
under,
for your
my lord,
I
Hello.
cannot grant stay of a case. You must
my
understand.
lord, when there is no
Yeah.
prima
There
facie
let be,
case,
let there be someone who will represent the client. I know it's bad luck for you. I understand.
extremely
My lord,
bad.
I mean,
my
this
lord,
is
before your
called
lordship
Tiresha
rises,
Toridova. I understand, but then let him be given an opportunity because he's without the
my
seat.
lord, before your lordship
His
rises, my lord.
complaint will be that I was not given an opportunity.
Before my lord rises, one lordship.
Also
My lord,
grateful.
my lord, before your lordship rises, my lord, এই ছেলেটাকে
One lordship, the first call, the state was not here. I went in the court number 1 to bring the state, and state call was done. And my lord, fixed it in next circuit.
Yes, and no further time can be granted.
Lordship,
I'm-
then can
My
I
lord.
be outside? In circuit in February.
If you don't mention, it will not be taken up. No? So they'll let
My
it
lord,
be.
with your lordship's kind leave, my lord.
Yes.
My lord, may I be permitted 2 minutes only,
Yes.
my lord. My lord, only one thing, my
Not
lord,
the
in the
mentioning
morning I
when
was,
you're aware.
my lord, in the morning I was mentioning, my lord, your lordship knows due to a glitch, my lord, I could not complete. Only one short matter, my lord. There's a motion, my lord, which is urgent. My lord, probably your lordship had indicated this was that condition, onerous condition, which was imposed upon a
You are
person, my lord.
asking for extension of interim order at the principal.
That was,
bench.
my lord, another case. That was another
Yes.
case, my lord, that has been done. My lord, over here, my lord, this is with regard to that onerous condition, my lord, which my learned friend was mentioning. My lord, in that matter, my lord, we have challenged it under 482 because it is an abuse of process of the court. My lord, a condition where every
Which
alternate
matter?
day in a
Which
fortnight,
matter? Item number?
my lord, I'm seeking leave, my lord, to move it on Monday.
Oh, no.
Seeking leave,
No
my
mention.
lord,
No,
lord,
no, no, no.
Passover item.
56 ka na? 56.
Compromise with that. Are you ready? Yes, yes, 2 or 5 actually. Who is appearing for the private opposite party? You are appearing? Matter is settled. I'll request the state to record the statement of the de facto complainant. What were the allegations? 498A. Can you come back on Monday with the report? Which place? Where does she reside? It can be disposed of. Let the statement come. Along with CRAN code, along with CRAN 1. Learned counsels for the petitioners and the private opposite party submit that the dispute has been amicably settled between the parties and the private opposite party does not intend to proceed with the matter any further. Paragraph. A learned counsel for the state is requested to submit a report on the adjourned date with regard to the amicable settlement arrived at between the parties. Stop the statement. The report should contain the statement of the de facto complainant / private opposite party in this regard. Paragraph, let the matter appear under the same heading to be mentioned later. On 23rd December 2020. 2 and 5, same order. Mr. Chakravarti, please try and get the report on that so that it can be disposed of. 6 and 7 also the same. 6 and 7 reports are there? Oh, you filed the CRAN today. So I'll pass the same order. Where does she reside? Both are from Siliguri. I'll give a direction to serve copy upon the state. And Mr. Chakravarti, I request you to come back Monday. Only record the statement of the victim that this is correct. It is submitted on behalf of the petitioner and the private opposite party that the dispute has been amicably settled between the parties and the private opposite party does not intend to proceed with the matter any further. Paragraph. Mr. Chakravarti, who is present in court and usually appears for the state, is requested to represent the state in this. Yes. Oh, right. Mr. Neeraj Chakravarti is requested to represent the state in this matter. His appointment be regularized by the appropriate authority. The petitioner is directed to serve copy. We have served already. The petitioner has served copy of the application along with annexure thereto upon Mr. Chakravarti in court this day. Paragraph. Learned counsel for the state is requested to submit a report on the adjourned date with regard to the amicable settlement arrived at between the parties. Stop. The report should contain the statement of the de facto complainant / private opposite party in this regard. Paragraph. Let the matter appear under the same heading on 23rd December 2024. Both the matters on Monday, same order. 7 or 8, 6 and 7, same order. Yes, the specially fixed matters are ready. 2 PM matters?
Yes, my lord, I'm here. Lord, permit to appear virtually. my
You were supposed to be there physically, isn't it?
lord. My lord, I couldn't come because of
Make
some
it.
other assignment, my lord. I'm sorry, my lord, extremely sorry.
No, that's fine. There are 2 passed over matters. Let me just.
Yes,
call
yes,
them.
yes, no problem. I shall wait, no problem.
Passed over matters, দুটো আছে না? Yes. I'll record none appears. This is not done. None appears for the Union of India. The matter be placed before the next available circuit bench. No. No further matters on that. You must understand this is a shorter period. This is a shorter period. Next. 56.
Yes, my lord, I am appealing for the victim. Respondent number 2.
Petitioner?
My lord, petitioners are not appearing before the trial court, my lord, and they are absconding. Yes, petitioners are not appearing before the trial court and they are absconding from the trial court.
You're asking for caution. This is a GR case. Have you served the state? Who is appearing for the state? Now he is no longer there. Where is he? Left.
My lord, there is a concealment of fact also on the part of the petitioners. The husband of the victim is not in the contact for the more than 4 years and possibly has got married with the help of the petitioner with some other girl and living somewhere else. Is not in the contact.
Warrant is pending. Surrender before the trial court. When will you surrender?
Yes.
Lordship,
Yes,
the victim girl is staying with us. I've also annexed the photographs.
My lord,
In 2023, she has celebrated birthday with us.
for one day they had taken in-laws had taken for the celebration of the birthday and conspiracy by making conspiracy they have photographed and they have tried to just allude the victim girl.
Since a warrant is pending, the revisional application will be dealt with later on. Surrender, take bail. When will you surrender? I'll stay the warrant for a limited period. I'll stay within 7 days.
Within 7 days.
The petitioner will surrender before the trial court within 7 days. The warrant will be stayed for a limited period. The revisional application shall remain pending. Let the state come, it will be dealt with.
My lord, there has been an attempt of the life of the victim girl. There was an attempt, and plus,
I'm not on merits at all, sir. Since a warrant is pending, let the petitioner surrender.
Yes, so,
And
my lord,
take and pray for bail. The learned court will deal with it. Please hear my order. None appears for the state. Paragraph heard learned counsels for the petitioner and the private opposite petitioners and the private opposite party.
my lord, there is one request that the bail should be given on the merit only, my lord.
I am not giving bail, sir. I'm asking him to surrender. Bail will be considered by the trial court.
Yes, that should be considered on the merit only, my lord.
By the trial court, not by this court at all.
Yes.
Since
My
this is
lord,
not a
by
bail
the
application.
There should be, my lord, I request for the observation that should be considered on the merit by the trial court.
Will you please hear what I say, sir? Learned counsel for the petitioner submits that the learned additional chief judicial magistrate Alipurduar has issued warrant of arrest against the petitioners Of charge sheet. Detailed order passed on 19th June 2024 in GR 1325 of 2019. Stop the petitioners seek to surrender before the learned trial court within 1 week from date. Stop. If the petitioners surrender before the learned trial court within 1 week from date and pray for bail, the learned trial court shall deal with the application in accordance with law. Paragraph, in the event the petitioners fail to surrender before the learned trial court within the stipulated time frame, the learned trial court, this is not the trial court, before the learned magistrate.
Lordship, maybe extend for 2 weeks. There is vacation in between.
The surrender within 2 weeks. 2 weeks from date?
Yes.
Within 2 weeks from date. The learned magistrate shall take necessary steps against the petitioners in accordance with law. Paragraph, the warrant of arrest issued against the petitioners, 3-day order passed on 19th June 2024 in GR 1325 of 2019. 2 weeks takes us to, today is 20th.
Vacation is there in between. That should be considered, my lordship.
I'll state in 8th January.
Yes, that's
In 8th January 2025. The matter be placed before the next available circuit.
highly object.
Obliged, my lord.
2 o'clock matters to be done. Same issues. Same FIR, different.
Different petitioners.
Same affair, my lord. There are 4 petitioners. All are, my lord, highly placed bank officials in HDFC Bank. My lord, a case of forgery and cheating.
State. Is the case diary there?
Yes, there is.
You are for the private opposite party?
I am for the private opposite party. Petitioner will not come before the lower court for bail.
There's a CRAN pending.
Yes, my lord.
After
All CRAN has been disposed of.
CRAN 7 is.
CRAN 7 has been.
So we are on the main issue now, right?
Yes, main issue.
Where is the state? Yes, Mr. Chakraborty, you have the CD with you? CD was called for on the earlier occasion.
My lord, may I proceed, my lord?
Yes, Mr. Chakraborty, yes.
My lord, these 4 persons, they are highly placed bank officials in HDFC Bank. My lord, a case of forgery, 420, forgery, 465, 468 for forgery for the purpose of cheating, and 471 using the forged document using as a genuine. This has been, my lord, so the case has been filed against them, these sections. If you will kindly go through the FIR once, I have annexed the FIR. Lord, it will appear in page 29. FIR dated 3rd of April 2024. Lord, this is the written complaint. On the basis of this complaint, the FIR was registered. Lord, what it, Lord, page 29.
Give me a minute. Yes, 29.
It's 1-page complaint.
Yes, please.
Lord, I am Dr. Swanso, the complainant, name of the complainant, one of the director of Heritage Hospital, a unit of mental health son located Bardhaman Road, Siliguri. This is to bring your notice that we had opened 3 current accounts with HDFC Bank at Heritage Hospital. The 3 number has been given. Then prior to opening the accounts, will kindly marked it. Prior to opening the accounts, Mr. Saurabh Das, Mrs. Devalina Mitra, Pankaj Saha had a meeting with us as an official representative of HDFC Bank, and we had told them we do not want any kind of transaction MDR charges levied on us for the POS machine. Milord knows POS machine is the point of sale. Point of sale. You have seen that the using of debit card and credit card whenever we purchase something, a percentage is being issued by the bank, and that is the reason this POS machine has been established. So, as per the complaint, we do not want any kind of transaction of MDR charges levied on us on POS machine and for cash pickup from our hospital premises. The bank representative had formally agreed to our condition that the operation of the account starts from July 2022. So there are two kind of assurance as per the complainant. One, there will be no transaction charges for POS machine, and second one, no charges for cash withdrawal from the premises of the hospital. Got it? That para says so.
Yes, yes.
Yes. So the POS team headed by Pritam Lama then installed the POS machine at our premises after getting the document signed. Will kindly mark it, Will after getting the document signed from the complainant. This is their case. After 10 months of the account in operation, our accounts team realized that the bank has taken transaction charges for all the payments made through credit debit card by our patients, and this amount to a huge sum of money. So bank was charging their transaction charges, a percentage of money. We then raised objection with the bank manager, Saurabh Kumar Das, as he told us that he will raise the issue with the higher authorities and take reversing it. We waited for 2 months and then we realized nothing is happening. We asked them to give us a copy of the agreement paper from POS machine. They mailed us the copy, and going through the agreement paper, I was shocked to realize that the signature of mine is very important. The signature of mine on those paper actually not mine, and they have forged it. This is his case. The signature which he has signed or there in the agreement paper is not his signature. On basis of this, Milord, a case has been started under these various provision of section. Milord, on 3rd of April 2024. Milord, got it?
Yes, yes.
Now, Milord, we have filed a supplementary affidavit before your Lordship's court in terms of the order passed by this court only. Milord, kindly take up that supplementary affidavit.
Yes. There are 2 supplementary affidavits. Oh, 3.
Yes, for each matter, but there are 4 matters, so we have to file 4 supplementary. Contents are same. Your Lordship, if you
same matter. The chapter of the
so if you Lordship go through one supplementary affidavit, it covers everything.
This is 141. Yes.
Yes. Now, my Lord, kindly turn to first page 4. Pursuant to the direction given by the court, we have, my Lord, filed this supplementary affidavit.
Yes, yes.
The petitioner submit that in view of a complaint lodged before the District Consumer Redressal Forum, Siliguri, page 4, B1.
Yes.
Petitioner submits that in view of a complaint lodged before the District Consumer Forum, Siliguri, by the same complainant, the petitioner wants to file a supplementary affidavit. Let the supplementary affidavit file within 2 weeks. Now, my Lord, what happened? When this FIR was started in the month of April, your Lordship has gone through the FIR. 3rd of April, this FIR was lodged, and immediately within 4 months, on the same issue, they have filed a consumer petition. My Lord, kindly turn to page 5. B2, page 5.
Yes.
My Lord, kindly see the date. It was filed on 7th of August.
Yes.
And your Lordship knows better than me, but in terms of section 38, subclause 9 of the Consumer Redressal Commission Act, every application filed under this act will be treated as a civil suit. That is the basic principle. Now, my Lord, kindly see the averments made in the consumer petition. But kindly see para 1, your Lordship can skip that we are filing it. But it starts from 2, that the opposite party is a private bank and provides banking and financial service, and it's a customer, it's a local office and address mentioned there. That the applicant is the customer of OP and holds his account, their account, so they had a business relation since long. But in the complaint, your Lordship will find, they said that complainant approached them only because of this to opening of current account. But they had a business relation from earlier also. It's a contradictory stand. Now, 4, the complaint states the representative approached them in the month of May 2022 for request to get the service of EDC machine free of cost. Got it? Page 4, Para 4, the complainant rely on the benefit presented to the OPs decided to avail the service of EDC machine, which was being provided free of cost. Subsequently, they
And
took the,
POS are the same thing.
Yes.
yes, same
POS are same.
thing. Subsequently, they took the signature of the first director, or kindly marked it first director on a form, who puts his signature under impression that the service is free of cost. So there is a first director also. The opposite party provided credit debit card swiping service for the purpose of making payment to the complainant. Subsequently, they linked the said service to the aforesaid bank account number so-and-so without providing any later agreement for this effect. It is a judgment of facts the case rising to the complaint case is at all a certain the complaint notice. Though the statement of account of OP is imposing service charges on every transaction conducted through the card swiping machine, as a result, the complainant raised objection to the OP and requested a refund the service charges deducted by them. But despite their verbal assurance, nothing was refunded. That the finally OP refused to refund the charges deducted by them on the ground of service charges payable as per agreement dated 13/6/2022. That the complainant thereafter requested the OP to provide the copy of the agreement by email dated so-and-so. Now, 10 is very important. That to utter shock and dismay the complainant when they notice the agreement contains the signature of the second director, whereas in reality the second director has not put his signature. But totally contradictory stand has been taken. There they said in their hospital premises it was signed now and he was one of the signatory. Now here he says he did not put his signature at all. This para 10 says. Then 11 says that after complainant issues the legal notice.
First director's signature is on a form, not the agreement.
Yes.
Different.
Different. Well, I shall come that. Well, they have annexed it. Well, I shall show it to your lordship. Everything is clear from that. But kindly turn to 11 then. The complainant thereafter issued legal notice after the unfair practice of OP, requested several times OP, returned to the service charge because the complainant had not consented to pay the service charges for EDC machine. Then opposite party reply efficiency of negligent service on the part but a silent point of the unfair trade practice. Then, my lord, your lordship will find the complainant thereafter replied the letter of so-and-so again because the OP to return the service charges because the complainant have not consented to the pay of service charges. The complainant humbly submitted the action of the OP constituted deficiency of the service and unfair trade practice as obtained under the Consumer Protection Act. We have kindly see, we have marked it. The opposite party's conduct is violation of the complainant's rights as a consumer and the complainant seeks appropriate redressal in the matter. That the complainant's consumer and protection of OP redress the territorial jurisdiction of the Honorable Court so-and-so. During OP refund the service charges, this is his prayer to refund the service charges along with the compensation. D, your lordship will find the compensation. So, my lord, few things is cropping up from this complaint which has been filed before the District Consumer Forum. Number one, that he has never signed on the agreement. This is number one. Although in the FIR he says in his premises the entire document was signed and subsequently it was found the signature which he has signed, it is actually not his signature. But kindly see the complaint FIR once again. Last but one para, page 29. First, your lordship, see.
The
One,
POS
two,
team headed by Mr. Pritam Lama then installed the POS machine
at our premises
after getting the document signed.
Yes, this is one. Now see the last but one para. The mail does the copy and from coming to the agreement papers, I was shocked to realize that the signature of mine on those papers were actually not mine. So he signed and then says it was actually not mine. Totally 360-degree turn in the Consumer Forum saying that I never signed any document. Now, my lord, kindly come to this document in question. Page 20.
Of the supplementary affidavit?
Yes, my lord. And before that, my lord, it is everybody's all over the world, your lordships knows, whenever there is a POS machine, the charges has to be paid to the bank. Everywhere in the world, it has to be given to the bank. Otherwise, the POS machine will not work. Now, page 20.
This is the application form.
Yes. Your lordship will find a Heritage Hospital Private Limited. This application they have annexed with their petition, the Consumer Forum petition. Now, my lord, see page 21, but there is a authorized signatory. Lok Bahadur Subba, my lord, got it?
Yes, yes.
Care of Heritage Hospital, my lord, he was present all along when this document was signed. Now, my lord, kindly turn to page 23. But this was the charges which was supposed to be deducted from the every transaction. 1%, 1%, 0.4 and 0.6%. Well, got it?
Yes.
Now see, my lord, the 24. It is very, very important. Here, your lord, you will find there are two directors. One is Heritage Hospital Private Limited. My lord, got it? Authorized signatory with company seal. So, my lord, he is saying that my signature is forged. He is never saying the seal is forged. The seal of the company is as it is.
The seal is only director. I mean, the first seal is fine.
Yes.
The second seal is only a director.
Yes, director. First seal, Heritage with the director. So it was agreed by and between the parties where the Heritage Hospital is one side and the bank was another side. He says, now see the another the signature.
Both the signatures have got the requisite seal. Both the signatures. Top and bottom.
Yes.
And this man, page 25, your lordship will find that Lok Bahadur Subba, who was another official signatory, he was all along present there and he made his signature there also, 25.
This is not signature. This is written in block.
Yes, yeah, whatever it may be, he was
not the signature.
Yes, he was all along present there. So, my lord, this is the case. My lord, now your lordship will getting first two contradictory version, my lord, from the FIR and complainant itself. Your lordship has seen that. Second, my lord, the Honorable Supreme Court in this regard, it is very clear, where even in a case of forgery and cheating also, if the similar facts are involved, the civil court is the appropriate forum to approach regarding the authenticity and veracity of the proceeding. But I am covered by one judgment, my lord. If you lordship see
This
the
is alleged forgery. This is not authenticity of the proceeding.
Yes,
no, same.
Same, the report of forgery lab report.
You need to come with an affidavit then.
Yes.
Maybe see
My lord, kindly see, my lord, Premjit Bhatra, 2011-13, volume 11, SCC 673. My lord, here similar thing was, my lord, done. An agreement was forged. My lord, tenancy agreement was forged. Criminal case was started, and also civil suit was filed. Now, my lord, kindly turn to page 8, 10, and 13. 8, 10, and 13. What the Supreme Court says. 8. Though the complainant attributes forgery and fabrication of documents to the appellant and other accused and states that the appellants have grabbed the profit of the running business and thereunder respondent number 2, it appears to us that essentially a civil dispute. Basic grievance of the respondent number 2, appellant has never given his account for his business. In our case, the commission which was taken was not given to him. Respondent number 2 made a reference to the written argument.
Altogether. This is a disclosure of accounts of the business.
But here also, my lord, the amount, the principal, my lord, what is the crux of the allegation?
But here it is forgery of signature.
No, my lord, the crux of the allegation, the money which was taken by the bank, that was not supposed to be taken. That is the crux of the allegation.
That is one thing. But the main allegation is the agreement shows a allegedly forged signature.
Yes, my lord, here, my lord, here, para 13, if your lordship sees that, as we already noted, here the dispute is essentially about profit of a hotel business and its ownership. The pending civil suit will take care of those issues. The allegation that forged and fabricated documents are used by the appellant can also be dealt with in said suit. But I am harping here. But if at all, it can be said that the allegation of fabricated document can also be taken care of the civil suit, because the 38 of the Consumer Protection Act has the power to deal with the forged documents, if at all.
Subject matter is different, Mr. Modi.
Lordship,
Subject matter is
Section
different.
100 of Consumer Protection Act, I am
Let him comment, let him comment.
Lordship.
But my lord, the CD which they have called for, it was called long back. This is updated up to 16th of May 24. I don't have the copy of the further investigation report.
Not only that, I think he should come back with an affidavit in
Affidavit also.
opposition,
Yes, Lordship.
referencing all the relevant documents.
Yes, Lordship.
Because this is purely documentary.
Yes,
Yes, but they have to prove the blood because investigation was never stopped. Blood from April, today we are in December. Now investigating agency has to show this signature, they have to send it to the FSL and they have to collect a report saying that the signature is forged. Then only will the case of
Has
forgery
to
will
be
lie.
before the QDB.
Yes.
Different documents.
I have collected from
How powerful you are.
How have you?
How have you
Yes, how he has collected it.
Lordship, Lordship,
It is a subject matter of
as
investigation.
I am the de facto complaint,
Maybe.
I will just inform Master to that the signature is the post.
The court should take note of this.
How have you, please show me that you have been officially informed?
Yes.
And you are boldly placing a document before the court, in charge sheet has been submitted?
No, not yet. Nothing.
Investigation stage.
Do you understand the consequences?
Lordship, that's why I'm asking to the public prosecutor
And
to
you are bold enough to place it before the court.
produce the.
I'll take cognizance of this.
But kindly take cognizance of
Has
this.
to, Lordship. Because in this fashion, the investigation has been like going on a different way.
It was said on 11th of June from the sub-inspector of police. You're not supposed to get this, this is a confidential document.
But kindly take notice of this. Lord, as a Lord, the High Court, Lord, the highest court of this state.
That's why I asked him to come back with an affidavit.
Lordship.
But kindly record that. They have to come up with the affidavit. How they got the document.
You are a learned advocate, sir. How many years of practice have you put in that you're doing this?
Lordship, I'm apologizing.
Let him come back with an affidavit.
Yes, Milord, kindly record that. Milord, how he has obtained, let him Milord file an affidavit.
Heard learned counsels for the parties. Paragraph. Learned counsel for the state submits that the case diary that he is carrying is not updated, and the entire case diary is required to be brought for the purpose of adjudication of the case. A paragraph, learned counsel for the private opposite party produces a document, produces a copy of document which indicates that the allegedly forged signature, which is the subject matter of the present case, was sent for examination and found to be forged. Stop. Since investigation of the case is still pending, it is not known as to how the private opposite party succeeded in obtaining a copy of the said document, which should be part of the case diary and ought to be produced before the learned trial court, along with the charge sheet upon completion of investigation. Paragraph, the private opposite party is directed to submit an affidavit disclosing under which provision of law he has obtained the said document. The private opposite party is further directed to use an affidavit in opposition. You want to come back with an affidavit?
Affidavit in opposition.
The private opposite party seeks to use an affidavit in opposition in this matter within 1 week.
2 weeks.
Paragraph affidavit in opposition be filed within 2 weeks from date.
My lord, our reply, my lord,
Yes,
our reply within 2 weeks.
1 week thereafter.
2 weeks, my lord, let it be 2 weeks. Yes.
Reply if any comma be be filed within 2 weeks thereafter.
Then it will be in February.
January, end of January, my lord.
2 weeks and 2 weeks take is 1 month, so circuit bench February.
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 I'll let it go out of list, mention upon completion.
Mention.
of
Right.
Let the matter go out of list for the time being.
There was a.
Liberty to
In,
mention.
my lord, interim order was there.
There was an existing.
There was an interim order?
Yes, yes. Till the, my lord, the circuit bench.
Till the end of this. Circuit.
End of circuit. And my lord, initial interim order was granted by your lordship only.
Paragraph, the interim order granted earlier is out of listed. The interim order granted earlier is extended till 28th February 2025 or until further orders come up.
Deeply,
Tapa, the matter be out of list, liberty to mention.
deeply obliged.
Same here, Khali Bira Lala. Same order in all the four
Same order.
matters.
All.
Deeply obliged.
Taking a leave.
At the pending list over?